that was sort of looking at the potential life cycle of an LLC. And I think after a meeting or two, we concluded that because we were just jumping everywhere and it ended up being a bit of a confusing journey, right. That we decided that we would go sequentially through the Act, starting at Article 1. And I think that's been the template that we've been pursuing now, going forward sequentially, section by section. Obviously, as you go through sections, there's often a jump back, particularly to the definition section in Article 1, where we encounter pertinent definitions. But there's other sections that we may jump forward to, at least to note the interconnection with the section we're working on with that later section that other group members then will be responsible for. It gives us the ability to flag those upcoming sections and that interconnection. I think, Sandy, maybe you can talk about in terms of the record we're creating here, such that at some point, in the hopefully sooner rather than later future, we'll have a deliverable that we can maybe pass to Legislative Council to spiff up an actual bill but based on our work, and I think we're trying to develop commentary with our efforts as we make particular decisions. I think along the way we've had lively discussion, engaged discussion, and really appreciate the folks around the table here, both the actual and the virtual table here this morning. But Sandy, I think it's maybe helpful to talk about the record we're creating as well.
So every meeting that we've had since, and I took notes before that, but especially since we started going section by section, what I've been doing is taking down the conversation the best that I can hear and understand it, and I also have it recorded. So for sections that I don't have the clarity on, I'll go back and listen. And I've created a master document, which, thank you to Valerie for her help in putting that together, is both a markup of the uniform laws sections themselves that we've actually worked on. Anything that's been changed specifically by consensus by our group is marked in red, specifically of what's been done. And then underneath that is a summary of the commentary that this group has had. And the goal is that document will be used to create the report eventually that will be given to the legislature in two parts. Obviously the markup is what we'll give the Legislative Council to allow them to actually write the law, which we hope to have passed, and then the commentary to go along with it. So this document is meant to be reviewed by all the members of this group, and feel free to comment on it directly on the document. It's a shared online document. Everyone should have access to it. The link I sent before the last couple meetings, but feel free to use that as a guide. My goal is to keep that constantly updated throughout the process and as we go. And
Sandy, would you mind including a link to that on the agendas going forward, so that people don't have to dig through and find the link?
On the agenda itself. It was in the email. I'll change that to the agenda.
Or the meeting notice.
Absolutely. Yeah, it is actually the meeting notice that I sent out yesterday.
Okay.
And it was the last meeting. So take a look at that.
Make sure it's easy for
Absolutely, yeah. And also there's a link to it. I also linked the website, which I've created for this group, which has a record of all of our meetings. It has the agendas, it has the notes, and then it also has the audio, if for whatever reason anyone wants to listen back to a piece of it, of our meeting. But it's also for the public consumption, so feel free to share that. And then the link to that constantly updated document is also available on the website.
Yeah, and I think going forward, one of the things I'd like us to do is spend some time in this meeting going over the markup and just make sure that we're all on the same page about it. Because the more that we do as we go along, the easier I think it will be for Legislative Council. So.
It's already almost 30 pages long, so that's just
let
you know.
Oh,
yeah.
All right, so the 30-page document you're referring to is not this.
That is that, actually.
Oh, that is this?
Yes,
okay.
That's our work so far.
Okay. So we are through section
209. Yeah, we had started 210, and we had a bunch of questions to talk to Secretary of State before we finished 210, and then move forward from there.
Right,
well,
and
actually,
we're going to need to circle back too, and I think was it 105 through 107.
Yeah, exactly.
So.
I have that on my
list.
After
I have to take this, so I'm going to yield to our Vice Chair.
Thanks, John.
All right, so now that everybody has been adequately updated, would you like to start the agenda?
Yeah. Thank you all for being here. I always appreciate it. Thank you, Miller & Ash, for hosting. One thing I want to touch on before we start our work, and we'll get pretty quickly to 210, is there was a point in the last meeting where we had discussed having representation of folks who are regularly working with small and medium-sized businesses. I kind of looked around at some of the conversation that happened there, and I realized that we had a great resource in the building I work in at the UO Law School with the UO Small Business Clinic. I talked to Minnie Whitcop and Chrissy Gibson, who work closely with small businesses, and especially in the formation of LLCs very often, and invited them to listen in today to kind of hear how the progress was going and just kind of talk with the group on how their expertise with those businesses might be helpful, especially as we move forward trying to get this passed and creating the legislation to ensure that we have that representation. So I know they're both on the call today.
Yeah, and thank you so much for coming. It's going to be invaluable to have your perspectives on this. Were we also able to reach out to Lewis and Clark Small Business Legal Clinic?
I haven't heard from them yet, but I do need to. If that wasn't part of my notes, but I will definitely call.
That would be great, thank you. Yeah, I just think that the different constituencies probably have additional things to add.
That's a great call.
Yeah. Okay. Well, thank you so much for joining us.
Okay, thank you.
Shall we start on 210?
Let's do it.
Okay.
Walker?
I drew a line when we finished our November meeting between 210A and B, just to maybe do a brief overview of what 210 is. As you can see in ROCA, it's the duty of the Secretary of State to file review of refusal to file and delivery of records by Secretary of State, and we certainly talked about last time that this is particularly an area of the Act where Jamie, your input is invaluable here, just in terms of. I have a sense as a practitioner about some of these 210 and some of the sections that follow, because there are a lot of ministerial provisions that relate to how basically citizens of Oregon and other states interact with the process that goes through the Secretary of State. We did cover 210A last time, ROCA, in saying that the Secretary of State shall file a record delivered to the Secretary of State for filing which satisfies the Act. And the duty of the Secretary of State in this section is ministerial. Counterpart section in ORS is 63017 and really says similar thing. Noting in 63017-4, it states that the Secretary of State is not required to verify or inquire into the legality or truth of any matter, including in any document delivered to the office for filing. So that's 210. As we concluded last time, I recommended that we stay with ROCA 210A. And that's where we ended, so unless there's further reason to pause, I'll dive into Section B. And that, in Section 210B, it says when the Secretary of State files a record, the Secretary of State shall record it as filed on the date and at the time, emphasizing those words, and we'll come back to that, of its delivery. After filing a record, the Secretary of State shall deliver to the person that submitted the record a copy of the record with an acknowledgement of the date and time of filing, and in the case, the statement of denial also to the limited liability company to which the statement pertains. So the counterpart section there, 63017, saying similar things. The Secretary of State files a document by indicating on the document the Secretary of State filed a document along with the filing. Interesting preface that follows in ORS, except as provided in a number of sections, and that's sections dealing with articles correction, resignation of registered agent, judgment of dissolution, escheat, resignation of foreign registered agent, service on the Secretary of State, and annual report. So a number of exceptions there that provide otherwise. After filing a document, the Secretary of State shall return the acknowledgement of filing to the domestic or foreign limited liability company or representative of the domestic or foreign limited liability company. So those are basically the counterpart sections to 210B.
I guess a question for the Secretary of State folks is, do we have the technological capability to record the time of a filing?
No, we don't.
And
Actually, oh, go ahead.
Well, I was just going to say, I think we did discuss that previously, and we had concluded that probably in ROCA we're going to need those references to the recordation of the time of filing. Really, the thinking is, it's probably it represents a change from what we do, and probably is not a critical item, and really the administrative burden on the Secretary of State's office to convert to a time stamping process. Jamie, correct me if I'm wrong, would probably entail some expenditure, some significant resources to change up that approach.
Yes, it would. It definitely would. It would take not only technology would we'd have to make changes there, but also staffing would probably have to change as well.
So I guess the recommendation with respect to 210B that I would have is firstly striking the references to time. So where it says shall be filed on the date and at the time, striking the words and at the time. So it reads filed on the date of its delivery. You see a similar phrasing later in 210B, acknowledgement of the date and time, striking the words and time. So it reads of the date of filing.
But this comes up elsewhere. I don't
It does.
recall exactly in
does.
prior sections that we've discussed, so.
I don't think we have. I mean, that's why I'm confused. I don't think we came to a consensus about this. And what I would like is
I wonder if we're giving up something if we take that out.
What I wonder is, so Cliff, you do a lot of work in other jurisdictions too, and a lot of other jurisdictions will have this time language. Do you think it makes a difference? I mean, because there are situations where you might want to register a name or something, right?
Well, no, I frankly, I think it's a discussion we already had in terms of it's nice to have a set time of day that something is effective, as opposed to, well, in that you can count on, such as it's effective as of noon, no matter what, filed on that day, as opposed to having to wait for the office filing time.
Yeah.
Our statute, correct me if I'm wrong, does allow us to specify an effective date and time inside the document, which is different than the administrative step of the Secretary of State, in this case, date stamping. And the issue would we want to impose on them the obligation to change the protocol to do date and time stamping? And I guess the question is, what do we gain from that change?
My recollection was that we had discussed it quite a bit and decided to strike the time language.
Right, that's my recollection, is that
Discussion at 207.
Yeah.
we did want some more input from Secretary of State, but
I mean, that's why I raised the discussion again. 'Cause we did, I have my notes all over 207 on this, but I just want to make sure that we are on the same page as the Secretary of State's office.
yeah, so that's, the recommendation I made is sort of based on, I think, what we had concluded, although we wanted some just confirmation, really, and I think Jamie has given us that the time stamping is probably something we're going to eliminate where it occurs.
So, did we, like in 207, looking at it, did we strike the appropriate language that makes reference, like 207-2?
So we had decided to get, my notes
We
show
struck
that we
two
decided
entirely.
to strike two entirely.
The whole section, yeah.
Okay.
Yeah, and then struck language in 1.
Okay.
And for one, we're going to use language from basically current 63.011 sub 1. And then in 207 sub 3, we're going to keep the words as they are.
Can someone do a digital search of the whole act to make sure it doesn't
That'd be
show
a
up
good idea.
elsewhere?
Okay. Yeah, absolutely.
Because, I mean, if it shows up elsewhere and we don't get it out, we create an ambiguity, a bit of a problem.
Okay. So otherwise, I think 210 worked.
The other problem with 210B that I see, this is Jamie with the Secretary of State, is that it says that it shall record it as filed on the date of its delivery, and we don't do that currently. So it's not, documents that are for business registry are not filed based on the date that we receive them in the office. So it's based on the date that we actually file them.
Okay.
So in other words, if you have a backlog, you may not actually, the filing date could be 2 days after you receive them?
Correct. It could be 5 to 7 days after we receive it.
So your time stamp, or you not your time stamp, but your date stamp on it, let's say I file it on a Monday, and your office doesn't get around to it till Friday, you're going to mark it filed as of Friday?
Correct.
Do you, on items that you receive, Jamie, following up on Cody's example, do you date things? Are they stamped in any way before processing on the date that they were received?
So we file according to the date that they were received. So like, take today, for example, because of the holiday and things, we're a little bit behind. So today we're filing documents that we received on the 30th of December, but they're not getting that date for December 30th. They're going to get today's date.
I feel like that might be a problem.
Yeah, especially if you're trying to do a merger or something
exactly.
that's be effective.
You need to have an entity.
Well, we have other avenues. So that is stuff that comes in by mail. So we also, our online filings are done within usually an hour of receiving them. If they bring it to our front counter, it's a different type of delivery. So it just depends on how it's sent to us. But the example that I gave is mail. If it's something that's mailed to us, then that it's 5 to 7 business days before it's filed.
I mean, the only situations I can see that having a deleterious effect, though, are likely to be, like the self-formed entities. So I'm curious what the small business folks think of that.
We don't have any issue. People who use service companies or or bring it to our front counter, or they can use UPS or FedEx and have it sent in to us. We get those things done.
I understand that. And for example, we always use Unisearch when we form entities or we do it online. But,
right.
We have the folks from U of O, Small Business Legal Clinic online, and I'm curious what they think about this. If they think it would have an impact on, your average mom and pop business owner who's trying to form an LLC. They have an expectation that it's going to be formed on a certain day, then they may be incorrect. So is
I
there
think that's true that they think, that it's formed when it's mailed or faxed into the Secretary of State. We are well aware of this time differential. We fax a lot of documents because of the way the client's payment is processed. But a lot of our entities who come to us who have already filed their articles have typically filed them online. And so then they are, typically filed on the online date. But we have not run into a lot of issues with that because when we're filing the articles for clients, then we do know about the lag and we inform them of that time delay when we're creating the entities. And I would say most people are not using faxes. So possibly with mail and there's a time delay. I have not seen any clients have any issues yet, though, when there is the 5 to 7 day delay.
I don't have a lot of sympathy for people who are just going to mail it in, having an expectation.
Yeah, I guess my only concern is that it's, there's sort of a digital divide in the society, right? And so we file electronically, we file using Unisearch. Does it have a disparate impact on folks maybe who are not as technologically savvy?
Well, I guess the question is, where is it going to have an impact on those folks? Because they're not the ones who are going to be doing complex mergers transactions. it's gonna be an issue for them when they form their corporation, because they're gonna just fill out the paperwork and they're gonna stick it in the mail, and they're not gonna probably have given it two thoughts about what day it becomes effective anyway.
Yeah, maybe not.
And
But what if they stick it in the mail and then the next day an officer signs a contract and the entity doesn't exist at that point? They could
Highly
step into a
likely.
trap like that.
right, and so then the question is, does it become, do they have to go back and ratify that contract for the corporation? And they probably do, and the contract counterparty probably should make them do that and check their status.
Yeah.
But that's really a problem for the contract counterparty, not the person who's forming the LLC.
Is there a reason the Secretary of State can't file them as of the date of receipt, or they may process them 5 to 7 days later? For mail, it
Yeah, like
seems like
stamp
the
it
state of
receipt.
Washington does it that way.
Right, it takes them weeks unless you
Yes.
expedite.
I think California does it that way too, is they stamp it on the date of receipt
Right.
and then they go look at it, and if it's accepted, it relates back to the date of receipt.
Yeah.
So it seems like that would be the best
So
solution.
is there a issue with doing things that way?
There's just going to be a cost to it, and I don't know. I mean, we'd have to find out what that is, but definitely that would be the one thing, is there would definitely be a cost to all of that. It would increase staffing for us. We would have to change our systems. And also, this is just LLCs, so the thing is we have to figure out then what happens to the other business types. Does everything have to change?
No problem, we'll cover that.
Yeah. So, Jamie, I think what you were suggesting is that for now, rather than it saying filed on the date of its delivery, filed on the date of its filing.
Or processing.
Yeah, I kind of think that this is one of those situations where we should flag it, because I think that what David is saying is accurate and what Jeff has said is accurate, where, we are surrounded by states that they will date it back to the date that it's received at the Secretary of State's office. And that's consistent with how stuff that's brought to the counter, how stuff that's faxed in, how stuff that is electronically filed in, as opposed to we will file it when we get around to it. And so I think it makes it more consistent with the states around us, and I think it makes it more consistent with how other things are transmitted to the Secretary of State. So I don't want to make the policy decision, but I do think that we should flag the issue to think about, and maybe John can discuss with some of the folks on, that he talks with, about whether this makes sense as a policy issue. Because just because there is an incremental cost doesn't mean we can shy away from it.
And Jamie, I think it would, for a future discussion there, if we can maybe get a sense on what kind of burden it would place on the Secretary of State's office, I think we do need to be sensitive to that, because, your efficient operation, I think, is an important part of what you do on behalf of the business community. And I'm also concerned that there could exist different procedures for different entities in terms of data filing versus data receipt and a relation back filing date for LLCs. That would we be expecting the Secretary of State to have different procedures for different kinds of entities? And
for a very short period of time.
Well, in geologic terms, probably so.
I think if we do this, though, it shall record it as filed as of the date of its delivery, as opposed to on the date of its delivery, because I do think that this is something where it's appropriate, because the Secretary of State needs to even out its staffing.
Right.
And somebody can stamp the mail when it comes in, and if they don't get to processing it till a week later, that's fine. But I think that it needs to be done as of.
Right, I agree with that.
Can I ask a question? What do you do if you have a filing for ABC LLC? The name's available.
Mm-hmm.
It comes in at 10 a.m. And you have a filing from another source, identical name, comes in at 11 a.m. Do you have?
Well, that's where the date and time and the and time deletion factor creates a problem there.
Jamie, did you hear that
How
question?
do you resolve who's entitled to the?
I didn't
hear the
hear it
question?
very well. No, I'm sorry.
All right, this is Di Lorenzo, and maybe this is an emperor has no clothes question, I don't know, but I'm just wondering what happens, let's say ABC LLC is an available name. And you have a filing from a lawyer in Eugene on behalf of clients for that, and it comes in at 10 a.m. on January 2nd. And then you have a lawyer in Portland with a different client who wants the identical name, and that filing comes in at 11 a.m. on January 2nd.
We make it worse, one's electronic filing and one's mail.
Right, or something like that, any of those permutations. How do you resolve the competing claims as to the identical name? What happens
So
now?
as far as the time, I mean, I'm trying to place that. So if they came to our front counter and the one filing arrived at our front counter at 10, and then the next arrived at our front counter at 11, then the 10 o'clock one would be the one that got filed first. If it came by mail, then it would be coming by mail on the same day, and so it would be a matter of whichever one, because all the mail just comes in bulk, so it would be whichever one we had first on the batch sheet, basically, whichever first one we opened up in the mail. If it came online, and then the 10 o'clock one would be filed before the 11 o'clock one.
Right, and if the 10 o'clock one was already filed, then when the 11 o'clock one came in, the name would no longer be available, basically.
That's
right?
correct.
So it's
The issue
applying
you
the
would
time
have-
and time without really having the language in the statute.
Right, I mean, the other issue that you could have is you would say, okay, what if you had ABC LLC from Eugene come in the mail on Monday, and then someone walks up to the counter on Wednesday, but they haven't processed the Monday mail yet,
Right.
right? I mean, I think that is a bigger problem.
Yeah.
How often does this happen?
Probably not tremendous.
I think
Yeah,
if
it's not something that I hear of very often. We get a lot of filings, so.
electronically.
Well, I mean, if they have access.
Or
that's
they'd
the
reserve the name.
problem.
Yeah, I say you have
Yeah.
reservation
Probably have
rights
a
too.
reservation, they
Well,
probably
anybody
reserve
can-
the name.
Right, but this is something that a lawyer would obviously do, right?
Right.
But my concern is the people who aren't lawyers.
We have public libraries, anybody can walk in and use a computer in any public library in this state.
Yeah, unless you're in Curry County or Josephine County where they've totally, or, you know, where they've basically defunded everything. So, I would question them for not paying property taxes.
Well,
I'm not
they
opposed
change
to that
it.
idea.
Well, one question I have is, it seems to me that by statute, right now, Secretary of State is required to record resignations of registered agents upon delivery of the resignation. I don't know if you all have like a separate thing to make sure if Monday's mail contains a resignation of registered agent, you hop on that one, even if the other ones don't get gotten around to until Friday. But I doubt it. I bet you're just treating it all the same.
Yeah, it would come in the same way.
So
We
it
don't,
seems,
so yeah, we definitely don't
so it seems
get
like
them right
either
off.
we could leave the statute as it is in the Model Act, which essentially puts you in breach but you already kind of are in breach of statute in this regard. Or we can give you an out by filed on the date of its delivery or as soon thereafter as is possible, something like that. Or we can leave it as it is, and then we have to up your funding so that you can achieve the statutory mandate. Are there other options?
But that's why I think it's a policy issue. Because I agree with Teresa's change to the language, which would be shall record it filed as of the date of its delivery.
Hmm.
Is
that what
staff
you
up
said?
just to do that too?
I mean, I would think there might be some initial costs to get caught up, but, you know, after that, it should roll relatively smoothly, right? Because you just have someone stamping it as it comes in.
It sounds really easy, though. It does sound easy, and I mean, whichever way it ends up happening, we deal with it. But it sounds like, yeah, it's just somebody that is stamping, but not always is it that simple. There's a lot of other parts that move with this. So, yes, now we have staff that are stamping all the mail when it comes in, and then we need more staff to do the filing when the filing comes in separately. So there's just sometimes there's more to it than just
No, I
stamping the
understand that.
document when it comes
That's
in,
it.
yeah.
But, you know, I think Cody's point is well taken, that, you know, potentially the Secretary is already not compliant with what it should be doing regarding registered agents. So, you know,
With registered agent resignations, I mean,
Yeah.
because that's an easy fix. We could definitely get to that point if we needed to.
Right, so is it that much more of an incremental cost to add the articles of organization stamping to the registered agent resignation stamping?
Well, this
Is it just the articles of organization, or is it any LLC document that gets filed?
Yeah, but, you know, we're gonna have the same issue when we get to the Corporate Act, when we get to the Partnership Act. You know,
Right.
I just had a conversation about the Nonprofit Corporation Act yesterday with someone. You know, so this is, I agree that there's a challenge when you have different treatment as between different types of entity. But, you know, this is not an issue that's gonna go away, and we are treating
No.
different types of filing disparately. And we are inconsistent with the states that are around us in this circumstance.
If, hypothetically, if we were to do at least some temporary curative amendments along with the new LLC Act that made the process of relation back of the filing date to the date of delivery and went into the other entity acts and made curative fixes so that at least the Secretary of State's not going to have to have a different process
Yeah.
for different kinds of entities, because I guess in my mind, I'm empathetic that spells chaos to me, that if they have to have different procedures for different kinds of entities,
No, I agree, Michael. I think that's a very good point.
So I think if we're going to go this route, we need to commit to add some curative provisions in the other entity acts.
Yeah.
And then, you know, we follow on with the, you know, the main revisions when we get there. But just, I think I'm sympathetic to some of the things that Jamie's saying here.
Yeah, absolutely. No, I think that's a really good point.
Well, I wonder if there's just, I don't know that the stamping the mail as it comes in, so that they know the date it comes in, so that when they get around to it on Friday, when they get around to Monday's mail, that isn't gonna save ABC LLC that got mailed in on Monday from being, not, you know, an open name anymore by Friday, because the other lawyer did it by electronic means on Wednesday.
Unless you went back to the time.
But you can't do that. Then what you
Well,
can
we
do
can-
is make everybody go as slow as the
Yeah.
slowest filing to
That's a good
get
point.
done. I don't think that really solves the problem. I think either you just have to recognize that people going by mail are gonna be last in line, or you have to up their funding so that they can do it. And I don't know how much the funding affects, whether it'll affect the passage of the bill or how much funding it would be, but it seems to me that's an inherent part of the policy choice.
You don't want to up their funding, because your bill will end up in the Ways and Means Committee and will never emerge.
Yeah, if we're other than neutral in terms of its
You
cost
want a
rating.
neutral fiscal
Yeah.
at the end of the day. Because we'll have the best hearing ever in the Senate Judiciary Committee. Everyone will love it. It'll go to Ways and Means by subsequent referral, and we'll never hear from it. Because there are other priorities. Nobody's gonna wanna, no one's really gonna care about us.
Yep.
When it's education and everything else, and Oregon State, and everybody wants their money. So I suggest whatever we do is as net revenue neutral as can be, and you know, for the Secretary of State's office, anything that you guys think that we change that would result in a fiscal, down there, please warn us in advance, okay? So like if you think,
Yes.
oh my God, you know, we're gonna have to hire another half FTE or something like that, we should know that right up front, so we try to stay away as much as we can.
I guess thinking about this for now, I think we should keep current protocol and have this as an issue where we, you know, potentially address it separately and globally across all the entity forms.
So are you suggesting then that these should read, when Secretary of State files the record, Secretary of State shall record it as filed on the date of its delivery or when they get around to it?
Well, I think looking
Well, it's not
at,
necessarily, that sounds a little bit brutal, I'm sorry. But it's not, I mean, we strive to get the filings done very quickly. I just want to make sure that that's clear. It's not, when they get around to it, kind of feels like, you know, we have different avenues that the documents come into us. So,
I understand that,
yes,
but
mail.
how would you word that sentence then?
The way that it's currently worded,
Or as of
document
date of
accepted
filing.
for filing is effective on the date it is filed by the Secretary of State.
yeah.
I mean, it's circular though.
63011.
I mean,
Well,
that's
and-
a circular.
Oh, but that's.
But maybe what we do with 210B is when the Secretary of State files a record, the Secretary of State shall record it as filed, period.
Or as of the date of filing.
No, because that gets around.
No, not receipt, as of date of filing, which means when they get to it and they file it.
Well, right, but I think what Teresa's point is
It's
that
the same thing, it's
it's
just
the
ending
same
the sentence.
thing, yeah.
Current 0172 says Secretary of State, and this is ORS, the Secretary of State files a document by indicating on the document that the Secretary of State filed the document along with the date of filing. I mean, so that's our current provision.
Which provision is that?
63017 sub 2.
So, yeah, filing is not a defined term in the Act. So, you know, I guess it just means shall record it as filed on the date of its filing.
63011 says effective date and time, effective time and date of document.
Right, but that's what Section 207 of the Model Act covers, is effective date. This is about, like, what timestamp, or, you know, what date
I
stamp
mean,
does
this
it have
is
on
to
it?
prevent the possibility that the Secretary of State, and I don't think our Secretary of State would ever do anything nefarious like this, but let's assume that you had a bad actor, and somebody tries to file ABC LLC, and the filing clerk looks at that and says, I don't agree with the political or the social or whatever message of ABC LLC, and I'm just gonna stick that in a drawer and not file it for 6 months. And
I arrested it.
it has happened in other places where people have done things like that. And I think that's what the point of this section is that things ought to be filed in the ordinary course or in due course or, you know, as soon as reasonably possible, or they just should get it done when they can get it done practically and not hold things or refuse to file them. Because this is really about refusal to file or unreasonable delay in filing.
How does as soon as practicable sound?
See, something like that I think would be fine.
Because then at least you'd have standards for a court to determine
Yeah.
whether they could have
Yeah.
filed it.
Yeah, I mean, it strikes me that after the word delivery, we could just say, or as soon as practicable thereafter.
Yeah.
And then we have to,
So 63011 also talks about when the Secretary accepts the filing, that would be the effective date and time. You could consider using when the Secretary accepts the document for filing.
But that doesn't solve the nefarious actor
Right.
problem. But the as soon as practicable certainly tells you that this is really intended to accommodate administrative convenience as opposed to a nefarious actor's beliefs.
Right. If there's a fire drill going on and it's going to leave the building. But when the drill is over, you get back to the, and you do it.
Well, I guess I'd like to think that, you know, ORS 56 governs the operations of Secretary of State, and if you had a nefarious actor, I'd like to think that there could be, you know, administrative remedies when that was ferreted out. So, I mean, I think you could say in B, shall record it as filed, and then borrowing from ORS, comma, along with the date of filing, something along those lines.
Actually, I guess I'm coming back to recorded as filed on the date of its delivery or as soon as practicable thereafter.
Yeah, I agree with Teresa on this one. But I do think that it's designed to avoid the IRS situation where, you know, they were like, oh, we don't agree with these people's political agenda. you know, so we're not gonna file it.
Jamie, did you hear Teresa's suggested language? Thoughts about that?
Yes, I did. Actually, I think that actually sounds good. The other thing I was kind of thinking, I mean, I know that it's not something that we could do right now, but I could find out if we could get a fiscal on like what would have to change and what the cost would
Yeah, that would be
estimate
super helpful.
if we made the change.
Because I
And that
think
might
the
be helpful. I know we have a lot of things right now on our plate that we're trying to get done for bills that have already passed, but I can ask if we can get that put on our radar so we could find
but
some time to do that.
Help in any fiscal.
No, I
Yeah.
agree.
As soon as practical just means whenever you can, as soon as you can, without undue.
Yeah, I would be interested though in what the cost would be, because we have this discrepancy between types of delivery
Sure.
and with the other states. So yeah, Jamie, if you wouldn't mind, that would be fantastic. Thank you so much.
Yeah. 'Cause
Yeah, and I can't
think-
promise how soon I can get it, but I will definitely
Yeah.
get that
You're not
out
in a
there.
rush.
Okay, so I think we're landing on the language on the date of its delivery, comma, or as soon as practical thereafter,
Sure.
okay?
Okay.
Done with B. C, 210C, if the Secretary of State refuses to file a record, the Secretary of State shall no later than 15 days, business days, after the record is delivered, one, record the record or return the record and notify the person that submitted the record of the refusal and provide a brief explanation in a record of the reason for the refusal. The counterpart there, 63017 sub 3, it's very similar. Secretary of State refuses to file, shall return the document to the LLC within 10 business days after the document was delivered, delivered, together with a brief written explanation of the reason for refusal. So I think substantively very similar. I would say stay with ROCA, but use the 10-day standard that is in current ORS rather than 15. That's bracketed, presumably for a reason, in ROCA.
Jamie, do you have any thoughts about that? I mean, is there ever the issue where more days would be better?
No, I think we usually wouldn't have a problem. It hasn't come up to be an issue for us.
Okay.
So I'm fine with sticking with the 10 days, or, I mean, the 15, either one would be fine, but staying where we're at is just fine too.
Okay. Anything else on C? Moving forward. 210D. Now, this is one that I think we're going to end up wanting to change. So let me sort of get all of this out with my recommendation, and then we can go from there. So for D, in 210, it says that the Secretary of State refuses to file a record. The person that submitted the record, and here's the beginning of my italicized language, may petition the appropriate court to compel filing of the record. The record and the explanation of the Secretary of State of the refusal to file must be attached to the petition. The court may decide the matter in a summary proceeding. Counterpart provision here, quite different, is 63.021, appeal from Secretary of State's refusal to file a document, saying if the Secretary of State refuses to file a document delivered to the office for filing, the domestic or foreign limited liability company, in addition to any other legal remedy which it may be available, start of my additional italicized language, shall have the right to appeal from such order pursuant to the provisions of ORS Chapter 183. and 183 is Oregon's Administrative Procedures Act. So you have very different routes from ROLCA to current ORS. One, you petition the court. The other, you go through Oregon's, existing Administrative Procedures Act. So my recommendation here is, the first part of the section D, we stay with ROLCA, so the person that submitted the record, but then we pick up the language from ORS, so the person that submitted the record shall have the right to appeal from such order pursuant to the provisions of ORS Chapter 183.
I have to say, I'm disappointed. I thought your recommendation was going to be the implementation of the Chancery Court.
Well, maybe someday. But I
have to stick with the administrators.
I think we really do there. And frankly, for I think a lot of practitioners, it's probably more cost effective to file an administrative appeal. And yeah, if you want to drive up the cost rating of that, presumably if they're having to defend immediately out of the Secretary of State's refusal a court petition, I would imagine our cost rating on this would bloom significantly.
Nobody's going to know what is summary procedure.
That was going to be my question about this section. The circuit court's going to look at this and say, what are you talking about? What am I supposed to do?
I could represent the petitioner, and Your Honor, summary proceeding, we don't even need to know what the defendant thinks. Nobody knows what a summary proceeding is.
All right, yeah, I agree with the recommendation.
I do too, although I would like a Chancery Court someday.
So it goes,
That would have
submitted
revenue
the
impact.
record, shall have the right to appeal for such order, restraint, or like that, or?
Yeah, so submitted the record and then jumping over to existing ORS shall have the right to appeal, et cetera. So we're kind of blending both provisions.
So everything after that last comma.
Should we include the in addition to any other legal remedy which may be available language?
Are there other legal?
I'm not sure there is, but
I don't know what else
it's
there
there
is,
now.
but I don't know why we would cut it if we're
Sounds good.
otherwise sticking with what they have there.
Yeah, I suppose it would be a mandamus. I mean, you could mandamus it to the circuit court if you really wanted to, but it would cost you 12 times as much. I don't know why
I'm
anybody ever wanted to
fine
do
with
it.
that. I couldn't think of what that would be, but, I would probably defer to creative lawyers if there was something else there. So I think that's a good suggestion. So submitted the record, comma, and then go to ORS in addition to any other legal remedy, et cetera, through the end of current 021.
Actually, the other thing I can think of is maybe there would be a remedy in bankruptcy court if this is a filing that was mandated by a plan or something. There may be a federal remedy.
That's interesting.
I mean, that would be pretty arcane because I have never seen anything like that come up, but I could imagine how that would be another legal remedy.
Good.
Okay?
I think I got it.
So if that's our conclusion, Sandy, does that make sense?
Yeah, I have enough that I'll piece it together when I listen back.
Okay, so, going through submitted the record
Yeah.
in D and then jumping over to 021, picking, put a comma after record and then adding in addition to any other legal remedy through the end of 021.
Yep.
So 210E, the filing of or refusing to file a record does not, one, affect the validity or invalidity of the record in whole or in part, or two, create a presumption that the information contained in the record is correct or incorrect. So our counterpart here is 63.017, 4 and 5, parts of that. So you see in sub 4 of 017, the Secretary of State is not required to verify or inquire the legality or truth of any matter. It's quite wordy here, included in any document delivered to the office for filing. The Secretary of State's filing or refusing to file a document does not A, affect the validity or invalidity of the document whole or in part, or B, relate to the correctness or incorrectness of the filing contained in the document. And then sub 5 of 017 goes on, Secretary of State's refusal to file a document does not create a presumption that the document is invalid or that the information contained in the document is incorrect. So Roka's wording is, you know, I look at these two and I guess certainly open it for discussion, but I think Roka's language is much more succinct, but I look at the two provisions and I think they end up in a very similar place. I think it's hard to say that there's major differences between the two, and Roka gets the job done in far fewer words. But that's.
I'm a big fan of far fewer.
So.
I don't have a problem with that language. I actually have a different issue I'd like to just put on the table. I don't know if there's a appetite to deal with it, and it's really a combination of D and E. What happens if somebody files a document, the Secretary of State rejects it, it is appealed, and the court determines it should have been filed? There's nothing here about relation back to the original filing date when the appeal is determined and the document should have been filed. And sometimes I can see, like in mergers and stuff, that can be a very problematic problem. In fact, the way I read this is if the document's filed, the Secretary of State rejects it, the court determines on appeal it should have been filed, it feels like to me then it gets filed as of the new filing date. There's no relation back to the original filing date, and that could be very problematic in some circumstances, and I just don't see it addressed.
Defer to the litigators here. Wouldn't it be part of the remedy that you request from the court as to get an effective date as of the date it should have been filed by Secretary of State? It seems like when you're seeking a remedy, you're going to want to have some sort of a relation back set out in your remedy, you know, if that's material to what you're looking to accomplish. But I don't know. Not a litigator.
Here's your problem, though. Let's say it's a matter of competing claims, right? And you think the Secretary of State was an error. So you file under Chapter 123, and it's an order and other than a contested case. So you go into circuit court. You haven't named the competing claimants.
Can you add them? You're not allowed to name
Well,
them?
you can't really add them because it's a Chapter 183 action. So you can't add them. They're not a party. You're now asking for relief from the circuit court that is going to affect other people, and they're not parties to the case.
Maybe that's a reason why you would do a mandamus.
Maybe.
Is that right?
I mean, I don't know if this will ever happen.
But is that right? Under the APA, you can't add some, you know, it's beef between you and the Secretary of State affects third parties. You can't add them?
I don't know.
I don't know procedure, administrative law well enough to know the answer.
But I know you could do it in a mandamus. You would name all the people that you needed to name in a mandamus. I mean, if the issue was they should have filed my name before they filed somebody else's name, and they delayed, and they shouldn't have done that, and the Secretary of State did something wrong. I mean, your correct remedy there, I think, if you needed to name other people.
Well, why don't you flag that section, and do we have law clerks now, Sandy?
We do for the commission. They're working on, I could.
Why don't we assign that question to a clerk, and let's see if there's a process let's see whether the APA would accommodate naming a third party as a defendant, and actually I guess petitioner's response. I don't know how that would work. Have somebody look into it.
Well, like the example I was thinking, just to put some meat in the bones, say it's a merger, you know, and there's a closing, you know, it's a big closing transaction, and everybody's banking on the date of the closing, and you file the articles of merger. Regardless of the effective date of filing, you don't find out for a couple days later from the Secretary of State that those articles were actually filed or they were rejected, but yet everybody feels like they closed, and they might be acting as if they closed and the two companies are combined. So that's an example of a transaction where it could be somewhat complicated and pragmatic in terms of the results if it gets rejected, because you find out a week later it's rejected. Now what?
Jeff, you're not gonna close a deal unless you got filing evidence, so it wouldn't close. But and I think the lawyer's remedy is getting, you know, to the extent they're good and getting things in order, they would have had these filings pre-cleared, if it's that big of a deal.
You're assuming that all lawyers are equal and that all deals are large enough to justify some of those levels of depth of.
Yeah, fair enough, but nobody's, I guess, ever have a deal where
No, this is
closed
very,
without filing.
I spotted the issue. This is one of those, remote, one in a million type of scenarios, but if it happens, it's just, it feels like there's a hole here in the language.
We'll look at it.
Jamie, I don't know of how much you've seen appeals through Oregon's Administrative Procedures Act. I mean, do you have anything to add on that in terms of if someone files administrative appeal and the filer prevails over the refusal of Secretary of State, how that's been dealt with? Any experience? I mean, obviously very narrow, unlikely situation, but.
Right, yeah, I've been with the corporation division for just about 10 years, and I've never been a part of one, or we haven't had one since I've been here. So, it's just not something, we haven't had an appeal, not for business registry. UCC, maybe, notary, but not business registry.
You could provide the filing for action under Chapter 183. It's incumbent upon the petitioner to serve a copy of the complaint on all those who had competing claims or something like that.
All those who would be affected.
All those who might be affected, yeah, you could do that, and then they can intervene if they want.
Although from a litigation standpoint, how do you decide who's going to be effective? If you're talking about the merger that's failed, is that every creditor of both companies? Because technically they are affected?
I don't know.
That's going to be.
Right.
I think as a general matter, you're going to have courts have enough power to do an effective remedy, and it sounds like this is an issue that hasn't come up. My guess is that most of the time when somebody gets a filing rejected, the answer is not to file an administrative appeal, it's to redo whatever was wrong and send it back in. Because I'm sure they reject lots of filings, but most of the time that's...
Yeah, rejecting filings, definitely, but to have it go to that level to get it figured out or fixed, we just have, that's not something that it's not typical here for sure.
Is the Oregon Secretary of State like the Delaware Secretary of State in that they essentially put the filing on hold, and when the resubmission is submitted, it will be given that initial filing date?
It gets the filing date of when of it actually being completed as far as filing. So it comes in non-filed if we reject it, but the actual date that it gets will be when we actually file it.
The relation back then.
Yeah, we don't go back to the original date.
Talked about earlier too, about, the filing actually occurs when they get to actually filing it.
Yeah, Sandy, we may want to just look at the Delaware code to see why the Delaware Secretary of State takes that position.
How they procedurally do that,
From the filing service, they basically just say it's been put on hold, and as long as you resubmit it within X date with this correction, or this item corrected, then
right, and
you'll
I'm
get the
sure
same
that
filing
often
date.
doesn't have any ill effect on any party. If you had a third party who had some filing that, that you're competing for ABC LLC, and the first to the punch gets held up by a rejection. The second one comes in and snags it, but then they don't because first get sort of retroactively. I'm just curious how they would handle that procedurally in Delaware.
Yeah, I guess with the Delaware filings I've had, it's been more charters and financings where it's referenced an incorrect date, where there's been a section reference there, and they reject it and say it needs to be corrected. So it's like the simple 2-second, you pop it and send it back, and we file it, and it still, again, has the same date.
Okay,
I'll look
so,
into it.
It's never,
so, Sandy, if you could have one of your clerks look into it.
Yep.
Maybe we'll talk about it next time.
Yeah, I have a note.
Okay, so moving on.
F of 210 just deals with the method by which the Secretary of State can return documents. So it's saying is except as provided in 119, which relates to service of process, notice and demand, or by law other than this act, the Secretary of State may deliver any record to a person by delivering it to one, in person to the person that submitted it, presumably that's over the counter, 2, to the address of the person's registered agent, 3, to the principal office of the person, or 4, to another address of the person provides to the Secretary of State for delivery. Comparison provision in ORS 630172. Again, we have except as provided in a number of statutes. After filing, a document the Secretary of State shall return an acknowledgement of the filing to the domestic or foreign LLC or the representative of the domestic or foreign LLC. So I guess my recommendation here first is to discuss that. In the commentary for ROCA, there's no explanation of this provision. It does seem to, and Jamie, I'd love your input here, the different ways to return this seems to provide the Secretary of State with maybe some more flexibility beyond what current ORS provides. But certainly would welcome your thoughts, Jamie, and the group at large here.
Also, I have a note in here referencing House Bill 2998 and 2325 with respect to electronic notice. And 103B.
We,
2325?
yeah,
Yes.
House
which
Bill
is-
2325 allows for electronic notification.
Right, so you look at, it's amending 56016, and I have that here. And let's see, Jamie, this is effective July 1, 2020, correct?
Yes.
Looking at section 4, this is Oregon Laws, chapter 62, and then it's amending, and really I think looks to be adding a new provision to 56016, and it's saying the Secretary of State may by rule, so it seems like it requires administrative rule adoption, specify a method including but not limited to an electronic method by which the Secretary of State will send a notice. And later on in that section, it's basically the default rule is still mail. So it's saying if the person does not elect to receive notice by a specified method, the Secretary of State shall send the notice by mail. So I guess I'm looking at this. I don't know if it's necessarily inconsistent with ROCA any more than current ORS is inconsistent with these new provisions in 56.
No.
I think they're meant to overlay
Right.
the entity acts when they're, because they're putting in them in 56.
Mhm. Yeah, that's correct.
Yeah, I just think, do we need to make any wording changes to sub F?
Should we just flag that for legislative council and let them figure it out when they write it? Because they're gonna have to incorporate all of that anyway.
And I think that's what we did with 103B.
Yeah, that is.
Yeah.
I mean, because whatever we tell them, they're gonna do whatever they want anyway.
Yeah, but I think you look at least comparing just the specific provisions in ROCA and ORS as it relates to this issue, I think they're reasonably similar. A little bit different language. I think I like ROCA that it maybe opens up some different options for Secretary of State, but then I'm seeing that the electronic notice, ORS 56, is just really overlaying it without necessarily being inconsistent with it. But, you know, I could be wrong in that reading.
Well, yeah, I mean, because you're saying in person to the person who submitted it to the address of the person's registered agent, this doesn't contemplate an electronic destination for that.
Mhm.
I guess we could say it's another address provided.
Yeah, and noting that 1, 2, 3, or 4, so it's disjunctive, it's providing a number of means by which
Okay.
I don't feel
Well,
like it's not specifically saying that it has to be by mail, just saying that it has to be, how it has to be delivered.
Well, yeah, and so it's saying, and I think that the sub 4, which says to another address person provides, is broad enough to encompass electronic notice, but I think that's a question for legislative council.
Well, and it's also saying except as otherwise provided by a law other than this act, which would include HB 2325.
Yeah, we just don't want to enshrine something that's in conflict with the,
Yeah.
Right, yeah, but like I think Michael just said, I don't see a conflict.
yeah.
Yeah, and I think that's a good point. I mean, I think that preface phrase it's actually better than current ORS, that I think it more comfortably allows the ORS 56 overlay.
Right. 211?
Hey, before we move on, I really hate to do this, but I'm looking back at our first section of B and how we amended it, and I don't think it reads the way that we intended it to. So when the Secretary of State files a record, comma, the Secretary of State shall record it as filed on the date of its delivery. So shall record it on the file of it, on the date of its delivery, or as soon as practicable thereafter. We're intending as soon as practicable. Aren't we intending to say that it's going to be recorded as of the date it is filed by the Secretary of State, which shall be on the date it's filed?
No.
It's actually delivered, or as soon as practicable thereafter.
Right, so I think the wording change that we made was Secretary of State shall record it as filed as of the date of its delivery or as soon as practical thereafter.
So the Secretary of State shall record it as filed as of the date of its delivery, or is what?
I'm not seeing your.
As soon as practicable thereafter is modifying when the Secretary of State actually has to file it, not when the Secretary of State shall record it as filed.
Right. So
something is delivered at the council at 5 or at 4:59, and for a reading, and it's in the bin. First thing in the morning, somebody comes in and files it.
Mhm.
That's basically. That would be the date of filing.
If nobody else sees it, then that's, but it sounds strange to me the way. I understand the intent.
Which is a real advantage to electronic filing, because if
yeah, always, because it just
electronically.
hits the system. I mean, so can you think of a situation where what you're describing, what the issue that you're seeing may come up?
It's not, it's just that the language is weird, as soon as practicable thereafter is saying the Secretary of State is gonna actually file it as soon as, on the date that it's received, or as soon as practicable thereafter. But that's not really as what the language, we're saying the Secretary of State shall record it as filed as of the date of its delivery. That's saying, because what Rolka is saying is that whenever the Secretary of State files it, it shall be filed as of the date of its delivery. And what we're saying is the filing date is gonna be the date that it's actually filed by the Secretary of State, which should be either the date of delivery or as soon as practicable thereafter.
Okay, so what wording change would you suggest?
Something like that is a little bit.
Shall record it as filed on the date of its filing, which shall be the date of its delivery, or I mean, is that what you're driving at?
Essentially, I was hoping somebody would be smarter than me and could say it a little bit nicer.
Paper cost is going up.
I mean,
I might defer to legislative council
Yeah, I
on
think
that one too.
okay, maybe just flag that for them. Then.
Yeah, and
Check the grammar. You're right, I understand your point grammatically.
Okay. As long as one person understands my grammatical point, then I feel
There's two
vindicated.
concepts based in the system. One
No, I
is
understand it too.
But when they do, here's what date it should get, and here's when they should do that filing. So they're like cramming a lot into this one sentence. Maybe it should be two sentences, but I would leave that to legislative council.
well, and I think based on what we've heard, it's not really an issue. Okay, 211?
Amazing. Okay.
We're almost done with 2.
Certificate of good standing or registration, 211, our counterpart provision, ORS, is 63.027. And to be honest, maybe I'm a little bit of a geek here, but I struggle with this one, and get into it here, and I'll explain kind of the tension there. So 210A says, on request of any person, the Secretary of State shall issue a certificate of good standing for an LLC or certificate of registration for a registered foreign LLC. Counterpart 027 sub 1, anyone may apply for a Secretary of State to furnish a certificate of existence for the domestic LLC or certificate of authorization for the foreign LLC. Okay, kind of similar there. But you read the two statutes, and then I think they depart significantly. So under ROCA sub B, a certificate, and again, this is a certificate of good standing under subsection A, must state. And let me stop there and jump over to ORS, which says a certificate of existence or authorization when issued means that, and they go on to list a similar list of things. And so when you look at ROCA, you have a list of various things that this certificate of good standing must actually state on their certificate. So sub 1, it needs the LLC's name. It needs to state that the certificate or organization has been filed. That's the articles of organization that we're using here. The date of its filing, period of duration if it's other than perpetual, that no statement of dissolution has been filed. The records of the Secretary of State do not otherwise reflect a dissolution or termination. An administrative dissolution has not been filed. Similar item for foreign LLCs, sub 3, sub 4, that all fees, taxes, interest, penalties owed to the state and collected by the Secretary of State essentially have been paid, and other facts in the record of the Secretary of State pertaining to the LLC which the person requesting the certificate reasonably requests. So this, you look at the content of that, and there's a lot of, it seems like a lot of things that the Secretary of State needs to include on that certificate. So, and again, I'm particularly now hearkening back to our burden on the Secretary of State cost neutrality issue. You compare what happens over on the certificate of existence, where, if you've seen a certificate of existence, there's not much to it. Basically saying, this entity exists and is active on the records of the Secretary of State. Now, maybe Jamie can, go through what happens sort of behind the curtain at Secretary of State when one of these are issued, but presumably, you look at what the ORS statute says, the certificate existent means that, the name is registered, it's duly organized by filing with the Secretary of State, all fees payable to the Secretary of State have been paid, its annual report has been filed, and no articles of dissolution have been filed with respect to that. Jamie, correct me if I'm wrong, but it seems like if we went the route of certificate of good standing and the certificate needs to list all of the elements you see in ROCA 211B, we're adding some burden there, but I could be wrong. But this is an area where certainly wanted your input.
Yeah, so it definitely would make some changes to our system, and then a little bit more work on our part of what we have to enter in. But currently what we do is we get the certificate request, we look up the name, make sure that it's active, make sure that it hasn't been noticed, so that there's not fees that are past due for renewals. And then once we make sure everything is good there, then we go ahead and process the certificate. And you were right, there's very little that our certificates of existence are pretty easy to look at. There's not a whole lot to them. So the changes that would be made here if it were a certificate of good standing definitely would change all of that with the certificate.
Can I ask another question? Is the process on the Secretary of State side any different in any material respect for different entity types? For example, a corporate good standing certificate?
We don't have to.
We're looking for the same things no matter which type it is. So we look for the same things no matter which type it is. So we're looking to make sure that they're registered, that they're active, that they're not late for paying the fees.
Well, it seems to me that the biggest change here, I mean, a lot of this, like, you need to look at whether they filed their most recent report. I mean, I don't have any problem with that because that's probably pretty easy for you to look at. The one that strikes me hard to look for and that you wouldn't necessarily have the information for is whether any taxes, interest, and penalties owed to the state are...
And collected by the Secretary of State. So you gotta get to the conjunctive there.
Like versus DOI.
Yeah, and
Right. Yeah, there's a lot of people, if you're looking at this from another state, you're not going to know which agency collects it. You may not totally understand what this is. Fees, I understand, because Secretary of State has fees, everybody has fees at the state government level, but taxes, interest, and penalties doesn't seem to me like it really fits here, given what we do. And that seems to me like it would be more of a burden.
Much bigger issue.
Well, but the Secretary of State doesn't.
I know, so why would we put in a statute that they would look at that when they don't collect any?
I don't know if it's forward-looking to provide that flexibility in the future if Secretary of State would impose a tax, which like a Delaware franchise tax, for example.
Right. I guess I don't know that we want a tax lightning rod in our bill.
Well,
And I think that's the difference too in the wording when you say certificate of existence versus certificate of good standing. Certificate of good standing does imply that they've paid everything up. They're good. They don't owe anything anywhere. I mean, it kind of makes it feels like it gives it a different level, something that we don't do here.
But that's still
for
covered
sure.
in the old, under subsection 2C. The certificate means when it's issued that all fees payable to the Secretary of State have been paid, so.
Right, that's why I saw the difference between
Right.
fees versus
Mhm.
taxes and penalties,
Right.
which are a whole different
I mean,
animal.
it says
Right.
collected by the Secretary of State, which they don't collect, so.
Right, but we're implying that they might, and that's gonna just create a problem for somebody.
I kind of view the annual report fee as a tax, but that's a different discussion for a later, later time.
And I guess stepping back to a larger picture here, I mean, these provisions I view as procedural law versus substantive LLC law affecting the rights of members and the operations of the LLC. My personal bias there is to try to keep as much in the Uniform Act as possible. I think here we're dealing with just procedures and interaction with our Secretary of State's office, and I'm probably less deferential to ROLCA there, and more likely to be deferential to Secretary of State in existing procedures. So I just that's my bias in looking at some of these different provisions.
And the other one that I circled so everybody can look at it is 2C regarding the duration, whether it's perpetual or there's a termination date. First off, that's not on the corporate side. It's something they would have to look on the LLC side that they don't look on the corporate side. And again, it feels more like that particular one fits into good standing and not existence, and will certainly add more burden, because I have a feeling the Secretary of State, and Jamie, you can tell us, does not look at that component.
No, we don't.
How much it seems to me that this will be a lot of additional cost.
I get that. I didn't know if it was.
Or a lot of additional time. I just, none of these things, most all of these things listed in ROLCA are already in the ORS, and the few that are new, such as the period of company's duration, I imagine are quick to look up and put in this certificate, and they can charge whatever fee they want for this certificate to offset whatever additional 5 minutes it takes for somebody to look up the information.
Yeah, that's true.
So why do you want to change from a certificate of existence? It seems like in the old days, if my memory serves, it used to be a certificate of standing in the state. The other thing we go through.
Can I make a comment? Hello?
Who is this?
It's Roberta. Hello.
Hi, Roberta.
I just was reading the comments, speaking of comments, under 211, and even though it says certificate of good standing, it really sounds more like existence, because it just says that a certificate's been filed, but not whether the company has been formed, and not whether it's been dissolved, and that the filing office is to make the determinations from public records only and not expected or permitted to make a more extensive investigation. So, I mean, I take the point that maybe the Secretary of State might have to do a bit more, but it really, even though it says good standing, it doesn't sound really like anything more than existence.
Look at subsection 6.
Yeah.
Any facts reflected in the records essentially as requested by the person requesting it. That's a scary one. That could be.
But it's limited to what the Secretary of State has in their records.
Yeah.
Although you don't want somebody
Right.
to say, I want you to go through every one of their annual reports and tell me what it says
We
in
can
the
order the
summary.
file. Right?
Right, but the question is, do you need the Secretary of State to create a certificate that, I mean, that would be a lot of work. If you had a corporation that had been around for 40 years, somebody said, I want the Secretary of State to do a certificate of good standing that says who was the president every year for the last 40 years. I mean, they could do that under 6, but it would be a lot of work.
Right, I mean, essentially
according.
it takes out a standardization. And, 6 makes it where these can be very specialized because of particular requests, and
Yeah.
that seems like a heck of a burden, and I agree exactly with what you're saying, Teresa. It seems like a heck of a burden on the Secretary of State. You don't know what it will cost and the time and effort will take.
Yeah.
You have number 6 there, and I think this does need to be standardized, so I was going to propose, I think that's got to come out.
I think 6 has got to come out, and if you take taxes, interest, and penalties out, and if you take duration out, you've got something that's pretty similar to what we have now.
But I will tell you from a transactional perspective, I would love, just for the naming of it, love it to be called certificate of good standing.
Yeah.
Frankly,
More
every
consistent
single
with
deal
the
I
data
get
state.
into, and I have to
Well,
explain to
out-of-state
the
counsel.
other, explain to their lawyer that, no, we don't, these organ does not recognize good standing, they have
Oh, yeah, no tax
active
clearance
status,
either.
and that's why the rep needs to be changed.
I
What?
run into this
What
with
kind of
every.
stupid state do you live in?
Yeah,
Yeah.
I run
No,
into
it's
every
true.
opinion of counsel I do. I run into this issue because they're always mostly out-of-state counsel.
Okay,
We can
so,
save our company legal
Yeah.
dollars by
So-
making this.
So I think we're gravitating towards
the vocal language,
the ROCA language.
strike 2C.
So, yeah, striking the B1C relating to duration,
2C.
Yeah, B2C.
sorry.
The language in 4 is reading taxes, interest, and penalties, and then 6.
So 4 will just read that all fees owed.
Yeah.
Okay.
I
Yeah.
think that's fine. There's no
And then strike 6.
So let me state explicitly the reservation I was getting at indirectly with my question, which is, are we gonna have a different certificate for LLCs than corporations in the state now? And what kind of confusion is that going to introduce? I feel like if this is gonna be changed, it has to be changed across all entity types,
Yeah,
which is beyond our charge.
raise a good point.
We got to start somewhere,
You have to start somewhere, Mosin.
and we need to move into the modern world because
I agree
Cliff
with
is right.
Well,
that
I
everybody
agree with
else
Cliff's-
expects it.
I totally agree with Cliff's point, but, I think that if we're doing it here, which I think I have no objection to doing it here, it has to be done everywhere.
I agree
Should we do conforming amendments in every other statute? I mean, we could propose that. I don't know that anybody's gonna pitch a fit about that.
Certainly when we get to the Corporate Act, which is next
I'm
on.
gonna propose it
Yeah.
anyway.
But that could be
We'll
3,
go
4,
back.
5 years
I know.
of lag time where we have 2 competing certificates
You know what?
in our business law practice.
Let's do this. Let's see how much they'll let us get away with. Why don't we have a separate section, Sandy, that will be conforming amendments
Yeah, I think that's a good
to
idea.
other statutes, and let's kind of keep that open, and let's put this one on it. But let's keep it all in one section, so that if it becomes a problem, we can have the judiciary committee amend it out. But let's, maybe they'll, because, you know, and I'm just thinking politically, if we get away with the conforming amendments, that would be a great segue to the next project then. Well, you know, this statute recognized that there were other conforming things that had to be done with the other parts of the Business Corporation Act, and our next project now is, you know, it might work.
No, but I have another idea to
Yeah,
address
yeah.
motion's concern. If you look at 63027, it says the certificate means. It doesn't say it will be in the certificate. It says if
Exactly.
it's issued, it means these things. And our certificate right now just says it's in existence. But the statute says when you get the certificate, it means these things. If we change the local language to not say this is what will be in the certificate, but if the certificate is issued, it means these things, then the certificate itself can look the same, and they're not going to have to change the certificate in any way. Right now, this language says, if you look back at the beginning, a certificate under subsection A must state all these things. So I think we go to the means approach in ORS, and I think that keeps the uniformity in the certificate itself, the form of it.
Does that solve your?
No, it doesn't,
problem?
because it would still needs to be called a certificate of good standing, right?
They need
Yeah,
to change
because
the
you got
label on the
another
form at a minimum.
Okay, but
But what
Granted.
you're saying is that you can keep the two-line certificate that says, instead of this company is in existence, it will say this company is in good standing, and it doesn't have to list out all the stuff, so
Exactly.
somebody's secretary of
right
state
now,
doesn't
the
have it.
language
But yeah,
here
yeah,
says the statement has to state
Right
that.
now, it's not, you're already going through and checking all these things, right?
But you're missing the point.
No,
It's what's
let me
on the
finish.
certificate.
Let me finish. How they generate the certificates, and correct me if I'm wrong, Jamie, is that the drop-down menu, and they say print certificate of good standing, print certificate of existence, and it prints a certificate that has the pre-populated information. And I think that's why it's important to get rid of 6, because that can throw a whole monkey wrench in the system.
They got to customize a certificate.
Right, so
Yeah.
you could put this additional language in the certificate of good standing by just changing the standard form.
But so are you, because the statute says the certificate must state all these things that we've
Yeah.
agreed will be in there, which it doesn't right now. So
Right.
they would have to change the look of the
But they're
certificate.
gonna have to change the certificate anyhow, if they call it a certificate.
I
mean,
think the
that's
difference
one way to
is, are
change.
we asking the
Yeah, it's not
Secretary
that
of
big a deal.
State to just change the name on the form, or create a whole new form?
Put some additional text in.
Right, and the question I have for those of you who do transactions where people ask for these, is do they care if the certificate has everything pre-populated, or does it just have to have that label on it and they just custom it? Okay,
Yeah.
then I think I agree with Jeff,
Okay.
that what we ought to do is change a certificate under subsection A means that it's effective and that it has paid its fees and there's no dissolution that's been filed and because if people don't care what the certificate says who are doing these deals,
Mhm.
and it's really the label that matters, it's a lot easier for the Secretary of State and cheaper for them to just change the name on it, and we can change the statute to fix that.
I think that's fine, because in the context of transactions, a lot of the elements that are on the punch list here, particularly if you're dealing with an out-of-state lender, they're gonna want some external verification documents on all of these things. And then they're gonna want the counsel for this entity to put their neck on the line in an opinion letter that verifies all of these things. So I guess in the context of actual deals, certificate of good standing, I mean, because sometimes we're dealing with a Washington entity and an Oregon entity, and you have to deal with sort of both flavors, and it's just kind of checking the box. That doesn't mean that there's not other elements that you have to prove, but typically you're not proving that in the certificate you get from the Secretary of State. So I think the punch list on the certificate, I don't know how much value it really is.
Again, I mean, I just issued an opinion yesterday for a North Carolina LLC that owns real estate here in Oregon. It's an enforceability opinion with respect to the deed of trust, and check the box, we see it. And again, when you have the statute that says that the certificate means, even though the certificate doesn't list it out, it's effectively, the statute does list it for you. You just need to look at the statute, because it's effectively incorporated into the certificate. So you still have the benefit of knowing that these things, when the Secretary of State issues it, are essentially approved or acknowledged by the Secretary of State. You just got to look at the statute for it. And again, I'm just trying to be, the concept where I brought it about was to be efficient in terms of not changing the form too much, although we've agreed we're going to change the form in terms of at least the title.
Yeah, the other thing that I think we probably need to keep is the date the certificate became effective. It is actually going to have to state that, and it probably currently does. The certificate of effectiveness is as of whatever date.
Yeah, they have dates on them.
Yeah, so I think that has to be stated, but the rest of it can go to me.
What do other states say? I mean, it's been a while since I saw one from another state.
Again, I got one from North Carolina, because in this case it was North Carolina LLC. It was actually a certificate of existence. I was surprised. It wasn't good standing. And it just said existent. And then we got the certificate because it qualified to do business in the state of Oregon. And interesting enough, it's a foreign entity qualified here. Their certificate called was certificate of existence, not of registration or anything like that. I was kind of surprised to see that because it really isn't in existence in Oregon. It's registered to do business in Oregon. So it was kind of interesting. But both of them said basically it exists. You infer that it was filed in Oregon and a date.
Right, but with respect to other states that have these certificates of good standing, what do they say?
Say it's in good standing on the records of the
Yeah.
state. I was
They're
trying to
usually
pull one up.
two-liners,
Like,
from what I can remember.
super
seeing of them.
short.
They're almost always like one page.
Well, and that's what I'm saying, but I
Yeah.
think it's expectation. I don't want us to have anything that's too far outside of the guardrails of what someone would expect to see in the deal.
Yeah.
You know, so if
I don't think
other
it would
states
be.
have,
I said I don't think it would be.
yeah, but that's the
Agreeing
thing.
with you.
But if other states have, you know, something similar where it just says, yes, it's in good standing as of this date, then I think that's probably fine.
That's pretty much been
I
my
remember
experience.
seeing from like Delaware LLCs. I don't think they say anything more than that.
Mhm.
I remember them being one pagers, and most of that is just still in the picture of them scrolling around the edges.
So maybe
I
we
looked up
should,
California, there's not a whole lot to it. I mean, it says legal status in a court proceeding, a thing like, I mean, there's not,
Okay.
yeah, it's very little.
Yeah, so, okay, so a certificate under subsection A means
Yeah.
under 211B.
Yeah, I think when the certificate under subsection A must state the date the certificate became effective, it means, and then all the other things.
yeah, I just wonder if C, we can maybe borrow some language from ORS, a certificate under subsection A, and then borrowing from ORS, when issued, means that.
Sure.
And then going through that section, we're striking 2C.
The language in 4.
In 4, we're saying that all fees,
Yeah, no, not taxes,
striking
penalties.
taxes, interest, and penalties.
And then 6.
And putting a period after 5 and moving the and up into the preceding section.
Yeah.
And striking 6 completely.
Well, we have,
See
Yeah.
on the next page.
yeah. Good, 212.
So we have actually sub C, which the subject to any qualification stated in the certificate issued by the Secretary of State under subsection A may be relied on as conclusive evidence of the facts stated in the certificate. So that's problematic based on what we just did.
Right.
Counterpart in ORS is sub 3 of 63027, saying subject to the qualification stated in the certificate of existence or authorization issued by the Secretary of State may be relied upon as conclusive evidence that domestic or foreign LLC is in existence or is authorized to transact business in the state.
How about subject to the qualifications stated in the certificate issued by the Secretary of State under subsection A may be relied upon as conclusive evidence as the facts stated above.
Yeah.
Or,
Yeah, that's good. That's good. And again, I mean, the certificate of good standing doesn't actually say that it's in existence. So it says it's, you know, been filed. I don't know. Does that mean it's in existence? I don't know.
that was the point you raised in the comments, just because somebody has filed
Yes,
an
it is.
LLC, they've actually finished the
Yeah.
formation that actually exists yet. And that good standing is
Right.
probably a more accurate term than in existence.
Right, 'cause we don't, there's no way for them to know.
Right,
Yeah.
right.
So how
Right.
about of
But I like
facts
Valerie's.
subsection B rather than above?
Yeah.
I think just consistent nomenclature
Yeah.
of the facts stated in subsection B.
Yeah. Works for me. Now 212?
Now 212.
I have a cross-reference to 202D here.
212 analog section in ORS is 63.787.
3 point, sorry, 77.
I guess I'll preface the comments here is, I think our annual reports reflect a fair bit of fairly recent legislative policy relating to public disclosure. ROLCA takes a very minimalist approach. I am certain we'll get pushback if we go with ROLCA here because of that minimalist approach versus the additional items of the content required in an annual report that our legislature has said that they want from entities. The other issue, ROLCA is based on an annual reporting system for filing on all entities on the same date every year, whereas our current process in Oregon is basically based on the annual anniversary date, in effect the birth date upon which the entity was originally filed. So where I get to here, and maybe to cut to the chase, is I don't think we can go with ROCA 212 at all for those reasons, and we can get deep into the weeds here on ROCA 212. And again, my point about procedural law versus substantive LLC law, I mean, this is just your annual report is a very good example of that. You're really not defining the rights and obligations of the LLC or its members here. This is really about public reporting and making sure the entities desire to stay active on the public record by requiring an annual report.
So, Michael, are there anything within 212 that you think are worth keeping, or should we just wholesale adopt 63787, bearing in mind probably some wording changes for consistency?
There may be some minor wording changes as it relates, but I'm just looking at what's currently required. And Jamie would love your input here, sort of on the overview I gave, and I'm presuming you'd be in agreement, but I don't want to put words in your mouth there in terms of, but I think if we went to every LLC filing their annual report all at the same time, that would be a little bit chaotic for y'all.
Yes, I would agree with that, absolutely.
Okay, because it seems like just the natural separation of everyone has a different anniversary date sort of really spreads this out over the year.
Mm-hmm, it does.
They're reflected in 63787.
Yeah. So I don't know what part of ROLCA 212 we'd even retain as I look through it and compare it to what we do as a state and what our legislature has really asked of us.
Right. Any discussion?
I think we ought to use 63787 and then just ask legislative council when they incorporate 63787 that they make the language conforming to what the rest of ROLCA does without changing the substance of it.
I agree. All right, look at this. We're done with Article 2.
Yay.
Now we go back.
Yeah, unfortunately.
And I'm prepared to, I don't know if we take a break now. I'm prepared to hit 106 next.
Do we want to take a 10-minute break before we,
That would be
let's take a
fine.
quick 10-minute break.
Also, just that you guys know, in case anyone wants to join me, Valerie, you might want to, on Monday, beginning of legislative days, and I'm going to be down at the Capitol, and Dexter and I are going to be together at 3 o'clock. And Sandy, you may want to join
Yeah,
too.
3 on Monday?
Yeah, well, it's either 2:30 or 3. I think it's going to be 3 o'clock on Monday in Dexter's office.
Okay.
And we're going to talk about the format.
Okay, yeah, I'll come just, yeah, sure.
Great, that would be.
Monday the 13th,
Yeah, Monday the 13th.
It doesn't talk about taxes.
3 o'clock, okay.
Yeah, but they have a franchise tax.
And
right?
Valerie, you're welcome to come, if anybody else would like to.
Yeah, I actually would like to attend that.
Dexter's Office Legislative Council,
Yeah, it's in the
Yeah, I-
legislative council,
I know where it is.
it's right near the Senate wing.
yeah.
Um,
And the meeting's definitely at the 3 o'clock.
Well, Dexter said 2:30 to 3, and I need 3
Okay.
to get back from another meeting, so I will call you or email you if
Yeah.
it's not gonna be 3, if it's gonna
Okay.
be 2:30. But
Okay.
Great, no, I think that would be great.
Great.
So, this is Susan Gravy. John, hi, guys. Is Dexter gonna have the drafter in there in that meeting as well?
I'm gonna ask him to.
And Sandy, you've been inviting, I forget his name, Sean, the drafter.
Yep,
Oh,
I've been inviting him,
continuously, right?
he's on all of our communication.
Yeah, I'll ask
Okay.
Dexter to invite Sean also.
Okay, so if I'm in the building, I will stop by if that's possible,
Okay.
just because I think it's really helpful.
Yeah, I presume, you favor our approach, that this be a complete revision as opposed to a whole series of amendments to the current law, right, Susan?
Well, I think when you do I'm not sure I agree with the language you're using. I agree with your concept, John. I think, yes, you're going to overhaul this act. I'm not sure I agree with the language. If it's a complete revision of everything, you're going to be, you guys are methodically working your way through the statute and looking at what makes sense.
Yep, what I mean is,
I think we're saying the same thing, we're just saying it in different ways.
all right, let me make sure that we're all on the same page. What I mean is, instead of having a whole bunch of ORS sections that are the current sections that then have strikeouts and italics and bold and all that which nobody can read, instead what we're going to say is a whole series of ORS are repealed, and in its place is going to be our version of the Uniform Act. Is that your understanding too, Susan? Because that's the only way, otherwise this thing is just going to be so complex. It's going to just be, it just won't be understandable. Now, for illustrative tools, we can always have red lines, if we need them. But the form of the bill itself, I think, should just be a complete replacement. Plus, this way, most legislators want to, if they're going to read the bill, they want to know what the new law is going to be. And it's going to be a lot easier to read unless we have a bunch of strikeouts, and there'll be half of the pages.
So John, I hear what you're saying. I think there will be people who will have, would want to see what is being taken out and what is being put in. And so I understand and appreciate your desire for cleanliness, a clean draft that you can just look at. I think people will have major heartburn if they don't, if they're not able to the people who care can differentiate between what is being stricken and what's being introduced.
All right, look, I
added.
do not have the meeting with Dexter Johnson and have both hemispheres of our joint brain not in agreement with one another. I I thought that this was the sense of the work group. If it isn't the sense of the work group, as soon as we get back from our break, let's talk about that right away. Because I want everybody on the same page, because I want us to be in complete agreement when we make an ask of this magnitude of Dexter. I don't want to get into that meeting and then have us not agreeing with one another, okay? So in a few minutes, when we get back from our break, let's just take this issue up, and let's just make sure that we're all on the same page.
Well, this is Lane. If I can weigh in on this, we can also task staff at the Uniform Law Commission to track this bill with the Uniform Act.
Sure. Yeah, but Lane, we're talking about like from a legislator's perspective,
Yeah.
what does this bill look like? And, is it going to be a gut and stuff, basically, or is it going to be a whole series of millions of amendments?
Okay.
Anyway.
So I do
Let's
think
talk
it's really
about it
important
about
to talk about that. I do think it's
We're
really
going to talk
important
about
to
that
talk
in
about
5
that.
minutes.
Yeah, Susan, we'll talk about it in 5 minutes,
Yeah.
but I think we already made this decision like months ago.
Yeah, but we're in recess
Right.
for 5 minutes. Okay.
All right, I'm gonna mute
Bathrooms are that way.
I'm gonna mute the call for 5 minutes, and we'll be right back.
Okay.
Hi, everyone, we're back.
We're all back.
Recaffeinated.
So Susan, are you back on the line?
I am, and so can you guys remind me which meeting it was that you discussed this? Because I guess I didn't track on this at all.
Okay, it was one of the very first meetings.
Yeah.
We attended, we brought up the issue, we then
I actually think it was the one at your office.
Yeah, in my office. We then had another discussion at a subsequent meeting. And because, you know, we were, at the time, we were trying to put together our work plan. And we were having some difficulty figuring out how to best approach this project. And we also, of course, you know, I'm trying to stay, I just make suggestions every once in a while as the chair, but I'm trying to stay out of the substantive conversations because you guys are all the certified smart people as opposed to me who knows nothing about the area. But I do want to keep my eye on potential, you know, the potential for getting the bill passed once we've got a final product. And so I have been asserting myself when it comes to things that will cause this bill to be referred to the Ways and Means Committee, which we want to avoid. And then also, it just seemed to most of us, I thought, after that second meeting, that this bill would look like a whole bunch of gibberish if we were just going to be amending section by section with italics and bold throughout. And it might be better to just, on a whole basis, repeal a certain group of statutes and then substitute for them the following, which would basically be what the law would be holistically.
Yeah.
So, and I thought that we had a consensus.
Yes, and we did have a consensus on that. And I think the intent of the group, and Susan, I think your point is well taken, that people will want some bridge between where we were with the old ORSs and with the adoption and implementation of ROLCA, is to publish something similar to what they did when they adopted the initial version, which Michael still has on his shelf. You know.
Sure, make me old.
You know, but that has, here's where we talk about these major issues, and I think we also agreed to commit to do training to educate the other members of the bar about here's what ROLCA says. But I absolutely agree with John. I think you know, we made a decision in the second meeting that we were going to go with ROLCA where, you know, sort of wholesale, with adjustments as we determine are appropriate.
Sorry about that. That was not a comment.
Well, I thought it was agreement.
I think she said gut and stuff, is what she said.
Yeah.
I think on
And
the wholesale.
that's a great term of art to describe it because that's the way people will view it. So that's my concern. You guys put so much work into this. I would just hate the perception to be that it's a gut and stuff and someone's trying to slip something by.
Right. Now, I understand that, but I think that is addressed through education and through, you know, publishing the thoughtful commentary that we've been developing as we go through, you know, which reflects all of the policy changes. You know, for example, we were just talking about some of these notice provisions and some of the information on the annual reports, you know, decisions with respect to transparency that the legislature has made, you know, that ROLCA certainly doesn't address.
The other wholesale thing that might suggest that we consider at some point is a delayed effective date once the legislature passes the bill, because I think we're going to need time to particularly educate the practicing community of attorneys and other people in Oregon's business community as to the changes the new act would entail. And I think if we reviewed as trying to pull a fast one, cram this down people's throat too quickly without time to make adjustments, I think that in of itself could yield pushback. So I don't know exactly when we're thinking this will land, but whenever it lands and hopefully is passed by the legislature, then having a delayed effective date to deal with that aspect.
And I would also hope that a red line of sorts would be present in our commentary.
Oh, yeah, absolutely. That's already being
And
constructed.
we're going to ask each substantive committee to actually recognize commentary as part of the legislative.
Yeah, I agree. I think that's important. And I think it's been useful what Sandy's been doing with the commission, as far as recording and preserving why we're making the decisions that we're making. Yeah.
Yeah, this whole process is being done along with the guidelines of the Law Commission with full transparency. We have a website where all of our meetings are recorded. The records of those meetings are being kept on a real-time basis. So we're doing everything we can to ensure that people understand that we're not trying to hide something.
I think one thing that we ought to consider, I think a red line, while we can certainly create one, is going to be very messy, and I think it'll be very hard for people to read. I do think that it would be helpful to create a list if there is anything in the existing ORS that's really substantive that we haven't decided to carry over, that we ought to make a short list of that and say, here's why we did that.
Sure.
I mean, and I think that makes sense to put in like one of those, like the book.
Well, and not as part of a big book, though, but something that's a bullet point, because what you want to be able to explain to the legislature is the policy choices that you've already made, for example, on transparency. We haven't undone those. We've moved them around, but we haven't undone them. Here are the limited subsets of things that we actually, they're not just things that related to a new place or we tweaked around the edges. Here's the 3 or 4 things that we had before that we didn't have now and why we got rid of them. If we have those things. That's really going to be what people are going to care about, is what's the where's the gotcha? That's what they want to know. And if we have one, we ought to be upfront about it.
I agree. But I don't think we have one so far.
So far, I don't think we do, because our
The personal liability one, I would agree with.
that may be something that
a
we
very, very significant change.
Yeah, we ought to have kind of here are the significant changes list. And I had thought about it as, there's a lot of what we have in ROCA that maps to an existing ORS.
Yes.
What we're going to do to form the LLC, for example. Are there going to be any sections in the existing ORS that don't map to something in ROCA? I think it's probably unlikely, but we might have a handful of things. And then we have to decide, do we want to add them somewhere, or do we want to jettison them? And if we jettison them, I think we ought to say so.
I agree.
Okay, so Susan, have we assuaged your concerns?
I hear what you're saying, and I think it's really important that, that now the Law Commission website has been updated. I think there was a little bit of a lag there with the transition to U of O, to getting anything up on the website or getting access to the minutes and things. I think that's been accomplished. I think that's great. It's really helpful. And I think the work that the Law Commission is doing with respect to a report is critical. I do think this is a departure from the typical approach, and I would cite the Nonprofit Act from last time, the rewrite on the Nonprofit Act, or the rewrite on the Uniform Trust Code. I think the tradition, and good or bad, but the approach from Legislative Counsel's office has been to redline, if you will, the existing statute. Whether they would choose to depart from that and do a wholesale, I don't want to call it a gut and stuff, because frankly I think that has really negative connotations and would be immediately suspect. But I think the approach of just eliminating the statute and then replacing it with a completely new language, while it may be easier, losing all the cross-references to other statutes, losing the reference to cases, I think that creates a whole cascading series of things to think about. It sounds like this group talked about it. I do think it may be more of an uphill challenge than you think. And my biggest concern is you guys have put so much work into this. It's really important. And I would hate for you to take that approach and then have people in the building think something's, that you're trying to pull a fast one.
Okay, so.
So maybe
first
you
of all-
addressed all those things. I don't know.
First of all, Dexter hasn't agreed to this, so this is an ask that we are going to make. But I want to have one ask. I don't want to go into his meeting and frankly, have other members say, well, we don't really know if that's a good idea, and we're not really all agreed. So I want agreement on what our ask is going to be. Ultimately, Dexter may decide that he doesn't want to take that approach. And, you know, we're one of those circumstances where even though they are our counsel doesn't necessarily have to do exactly what we ask them to do. So.
But I do think, you know, we had Emily involved in those
Right.
early discussions.
Yeah.
I think Emily, having
And she was
come
comfortable.
from, Emily having come from legislative council, has a very good perspective on,
Right.
you know, Dexter's process. So I agree. I mean, I think it's an ask, but I think it's an ask that I'm comfortable making.
So anyway, Susan, I think the sense of the committee, I mean, we could vote on it if we want, but I think the sense of the committee here is that we want to make this ask. And the ask I have of you, you're certainly welcome to come to the meeting, but I really don't want a minority viewpoint presented when we are just asking Dexter for permission to do this. So are you comfortable with that?
You know, for whatever it's worth, back in 1987, this may be too long ago, they did do a got the stuff thing on the corporation.
I know they did.
So
Yeah.
there was some precedent for it.
Yep.
Susan, are you still there?
Yeah, I'm still here.
Cogitating, yeah.
I'm cogitating, and if this is the will of the group, so be it. I probably won't attend the meeting because I'm uncertain as to whether it is the best approach. So go forth, and if your group has voted on it, go for it. And maybe Dexter and Sean will be amenable. I do think there are other hurdles to overcome just to ensure that all your work doesn't go for naught.
Right, and of course, you know, the reason we're suggesting this, because we feel that if we take the traditional approach, because we're rewriting such a large section, that we will have equally daunting, you know, challenges. So anyway, thank you, I appreciate that very much. This is the email I'm going to send back to Dexter. The meeting's at 3:00. So I said, great, I think Sean Brennan is our drafter. He has been kept up to speed, although he has not had a chance to participate in many of our meetings. It might be good to have him there too.
Yep.
I will bring our vice chair and one or two members to talk through what we perceive to be the advantages of the structure we wish to propose. Okay? Cool, I'm sending it now. Excellent. Okay, thank you very much, and I'm going to yield back to Valerie.
So I will yield directly to Michael. Section 105?
Oh, yeah.
106.
106, rounding third base,
Excellent.
sprinting to home plate. Deals with operating agreement. I think it's helpful to look at the definition of operating agreement in ROLCA and the comparable definition in ORS as foundation to really understand this. So the ROLCA definition is in 102 sub 13, my draft, that's on page 10. Operating agreement means an agreement, whether or not referred to as an operating agreement, and whether oral, implied, in a record, or in any combination thereof, and all members of the LLC, including a sole member, concerning the matters described in section 105A. The term includes the agreement as amended or restated. Okay? And looking at ORS, and we are at 63001 sub 25. considerably shorter. An operating agreement means a valid agreement, a valid agreement, written or oral, of the member or members as to the affairs of a limited liability company and the conduct of the limited liability company's business. So, I mean, there's certainly some corollary there, but I think if you compare the two, at least as you see in the statute, and I think there's words in ORS that you can unpack and maybe get the ultimate meaning of those two definitions closer to one another. Certainly the breadth that you see in ROLCA is broader. An agreement, oral, implied, in a record, or any combination thereof, meaning that you could have elements of your operating agreement that are scattered between really oral agreements, things that could be in a record, meaning a filed document, and other pieces of writing that float around that when you pull them all together become the operating agreement. That's generally not what you'd consider, at least from a practitioner standpoint, is a best practice. But those are the two underlying definitions. So I'll pause there if there's any. I just wanted to ground us there. So 106 and
Can I raise something with the definition in ROLCA? And again, this is a very technical argument, but what it says, or any combination thereof, to me is a little problematic if you have a written operating agreement that has an integration clause, which is pretty typical miscellaneous provision, that says the entire agreement is in the four corners of this document. And yet this statute says that does it vitiate an integration clause such that somebody can argue there's still an oral piece over here?
I doubt it, because I think ultimately a court's going to have to first bring their interpretation of contract as controlled by Oregon law to the bench and make a determination as they would any other contract as to that issue. So I don't think the definition here eviscerates the court's ability to do that. It's just if you don't have a nice, clean operating agreement with a good integration clause, like Jeff would always draft here, then I think it allows the parties to bring evidence to the table.
I think that's the intent, but for the reasons just Jeff mentioned, I don't like this language either, because it opens the door to a court saying, well, the statutory definition overrides the common law of contracts.
I don't think that's going to happen. I appreciate the possibility. I assign it under 1% probability.
On what basis?
Because I don't think there's going to be any indication that there's an attempt through the statutory language to override the rule regarding integration clauses. It is saying, I think everyone will read this to say that if you don't have an integration clause, as is true of any contract, and this is just stating what the common law of contract is, I don't think everyone's going to say, oh, they meant to undo the integration clause rule. I just don't think that's going to happen.
I mean, this is a statute that overrides the common law to the extent it says that an operating agreement may be oral, implied, written, or any combination thereof. It's susceptible to the interpretation that an operating agreement is all of those things, implied by conduct, oral, and in writing. And we look at the entire combination of things.
But you do that already.
So the commentary,
some helpful commentary
that's not the intent, but that's the commentary is in the statute, and I don't think you should bury it in the commentary.
And I think we talked about the book on our shelf. I think ultimately part of the legislative record needs to be the ROLCA comments, and then grafting on top of that this committee's commentary, and ultimately the bill there. So because I think where we've had Uniform Acts adopt, it's very helpful to look at the Uniform Act and look at what, if anything, the state legislature did in changing that. But it's very helpful. I still have the commentary from the Revised Model Business Corporation Act as well. And going back into the commentary of the Uniform Act is often helpful to, particularly if what the legislature passed is consistent with that. But you look at the commentary, page 15, an operating agreement is a contract, and therefore all statutory language pertaining to the operating agreement must be stood in the context of the law of contracts. And so I think if this is part of our legislative record, then I think, this is one of the things that I think keeping with such a core definition in ROLCA, I think is important. The commentary, I think, is helpful. Go on. The definition in paragraph 13 is very broad and recognizes a wide scope of authority for an operating agreement. Quote, the matters described in 105A. Those matters include not only all relations inter se, the members and the limited liability company, but also all activities and affairs of the company and the conduct of those activities and affairs. And I think that's, you can read the rest of the commentary at your leisure.
I guess my concern is that third parties rely on operating agreements to know that the people that they're dealing with have the authority that they're dealing with. So let's imagine the following situation. Bank wants to make a loan to LLC, wants to make sure that the person signing for the LLC actually has authority to do that. And the written operating agreement says the president and the CFO are the only ones that have this authority. So bank looks at that and relies on that. And then it turns out that somebody tries to do something and they have agreed by context that even though the operating agreement said the CFO had authority, it turned out by conduct the president does everything and the CFO never has any authority to do anything. So I'm a little bit concerned with language that is as broad as this is, that people could be misled by looking at a written operating agreement that has been modified either orally or by contract, that they don't know about the oral modification or the contract. It seems to me if it's in writing, the writing ought to govern. If it is not in writing, then sure, imply it from conduct or whatever anybody else is, because a third party's not going to rely on that. But I do have concerns that this idea of in combination could make it so that unwitting third parties think they're dealing with somebody that has authority that doesn't actually have authority.
You could, for example, currently have a written operating agreement, and the definition of operating agreement provides for oral modification, right?
Right, but at least the third party looking at that has the opportunity to look at that, see that it says that, and then get a representation and a warranty in writing that there have been no oral modifications. But if you're dealing with something that's as loosey-goosey as this is, you're not even really on notice that there's a problem.
So I guess I'm just trying to think about how this is really a problem. So if you have a written operating agreement that says integration clause,
right,
and can only be amended by a written amendment,
right,
then you don't have to look anywhere
You
else.
don't have to worry about an oral.
I think that's right.
So the scenario I'm
Except what
envisioning isn't a
he's
third party
envisioning.
scenario, it's a member dispute scenario. But I think we get to a similar place. So one member says, hey, we have a written operating agreement with an integration clause, case closed, contract law prevails. The other member's creative lawyer says, hey, the statute supersedes the common law, and the statute says that an operating agreement is not just the writing, but it's the writing and anything else that was implied through the party's conduct, because it's a combination of writing, oral, and conduct. So we can't just look at the operating agreement, notwithstanding the integration clause. I think that's a bad argument, but I don't want to be litigating that if I were a lawyer, which I'm not. I don't want to be litigating that in circuit court in Multnomah County.
Right. I think it's an exceptionally bad argument, especially when you look at the commentary,
But
the definition of operating agreement.
But you're expecting a Multnomah County Circuit Court judge who doesn't do LLC disputes all day to look at the commentary to a new LLC statute. I would get nervous about that.
Well, the operating agreement is still
People
the
can sue
agreement,
for
and there may
anything.
be a dispute about that, but that's more of an evidentiary issue, and this allows you to bring in, I think, whatever evidence you could bring in under normal contract.
Right. So my proposal would be to just strike the any combination thereof to not invite that argument to be made. Even if it's a bad argument, I think that language is needlessly confusing and invites that argument.
And
Yeah, I agree with that.
And to back up,
I-
this comment, that's consistent with Delaware law.
What is?
The Delaware, the
It just
Delaware
says you can have,
definition
does it say you can
does
have
not
implied terms?
The combination of it.
But so if you have implied terms, you can't have written terms, or if you have written terms and no integration clause, you can't have an oral
You
part
can still
of the
have it,
contract
but
too?
there's no statute that says the common law way of figuring this out under contract law. The common law of contracts is superseded by statute.
Can we say in our own commentary what we mean here from the standpoint that we're not intending to override, Oregon's law of interpretation of contracts, and that the definition of operating agreement shouldn't be interpreted otherwise?
Yeah, I mean, I'll just point, the commentary, the rule does say, on the question how far a written or in a record operating agreement can go to prevent oral or implied effect terms, see section 105A4 comment, which then goes on to say, under section 111 supplemental principles of law, the parole evidence rule will apply to a written operating agreement when appropriate under contract law. So it's, point being, it all just goes back to basic contract law, under which, first of all, the thing you're complaining about is just stating the standard common law rule, which everyone knows, and all the cases hold, is subject to the integration clause rule.
I just wouldn't want to rely on the commentary to do the work in the statutory text ought to be doing.
But I don't think we are.
I guess I disagree that the ambiguity is there, or to the degree that it's there, I think it's vanishingly slim and could be resolved by us putting something in our own Oregon commentary that just says integration clause rule still applies.
I'm fine with that if that's the consensus of the group.
And I guess I'd also point out a scenario, the hot mess scenario where, say, two contractors go online, they file their articles of organization, they do nothing else. But amongst them is a combination of oral agreements, implied agreements, some things that they put in writing that on day one they knew what their deal was, how they're going to operate, who has authority, and what the economics of their deal is. But it's, let's call it what it is, it's a hot mess. And then they get into litigation. Okay, it's a typical kind of case. If you're litigating that, you're drawing evidence from a whole mess of different pieces, because they don't have this pretty operating agreement with a nice integration clause.
And I agree with that, because I just made that same argument to IRS, in an appeals, and it worked, right? So, your clients come to you with whatever hot mess they come to you with, and I don't think it creates additional uncertainty to have that language in there.
So
Whereas the state of Washington kept in the Oregon denomination thereof, also you play.
Yeah.
And it just strikes also, if you delete it, then the judge who's reading this is going to say, oh, they deleted the or the combination thereof. So the operating agreement is either all written, or it's only the oral terms, or it's only the conduct terms. I can't do a combination. And when you're trying a case based on an implied contract, you are relying on oral and written.
And the email they sent, the link.
That's all part of the implied contract. But apparently this would indicate that you couldn't do that. You have to rely purely upon the nod of the head or the course of conduct of paying on the 11th of the month.
So which position furthers the policy?
Just leaving the language. Well, we can vote on it. I mean, I would be okay if we want to take a vote on it.
No, but philosophically, which position, furthers the policy that you want?
Well, I think
I think we made a decision that we were going to keep with the rule language, except to the extent that it made sense to deviate from it. So the question is, does the committee think that it makes sense to deviate from it in this instance?
I wonder if there's another approach here, which is to somehow add a reference to preserving Oregon contract law in this definition. So operating agreement means the agreement, made in accordance with Oregon law of contracts, however you would say that, whether or not referred to, and continue, so that it's clear that we're continuing to adopt the Oregon law of contracts.
One issue there is single member LLC can't be contracts under common law because one party is agreeing.
But you have statutory. There's section 111 of the rule that already says anything that's not overridden by this, the common law is still applicable.
That's what I was looking for.
I don't think we need a special call out for, I guess, the law of
45.
contract formation.
Related to operating.
or contract interpretation is especially called out. And part of me thinks also the operating agreement, since it is the thing that drives the whole concept of the LLC under, I mean, even under current law, but I feel like this is something where we extra want to be in line. I mean, I guess I don't, and part of me, I don't want to make a big fight about it. I find myself in the unusual position of being more pro liberty of contract than most, and in this instance, I think.
I mean, do we want to vote on this? Yeah,
I'm not
no,
quite
we-
sure,
we-
can somebody articulate the issue in
There's,
a couple sentences?
I think there's some people, including myself, who feel like this statutory language invites the possibility to have a written operating agreement with a merger clause. And under the common law of contracts, that would normally preclude the admission of any kind of parole terms to supplement that agreement.
Okay.
However, there's a concern that this statutory definition would lead a judge to say, well, traditional contract rules do not apply in this case because the statutory definition of operating agreement says any combination of these three things. And so I can look at the writing, but I can also look at implied terms. Others feel that the commentary and statutory language feel is sufficiently clear to suggest that no, that's not the case, and that it's an unlikely issue to come up in court. And so I think that disagreement is how big of a risk this is if it gets litigated.
You know, and I would add that, you know, when we talk about policy, I think one implicit policy is we don't want to be adopting language that's going to increase litigation and congest our courts because we open the door for this ambiguity or not, depending on what side you are here. So my approach was to get clarity here. So Teresa had mentioned a moment ago, adding something to what's in the notes already. Adding something maybe to the statute, so we're not relying on, you know, statutory notes or adoption notes.
Does anybody know why the Uniform Act included that language?
I think to enhance freedom of contract, frankly. I mean, this is the most free. You can do it however you want.
Well, and I think there are a lot of situations, like for example, my IRS case, where you have people try and draft their own agreements, and they do a terrible job. But they have, you know, a pattern of practice, or they say, yes, you're gonna make these decisions. You know, so you want to be able to bring those in when you're having a discussion about what is the deal. I mean, what are people's understanding of the deal?
For course of performance.
Yeah, and so you have evidentiary issues. But you're gonna have evidentiary issues regardless. You know, it's not the situation where you have like two parallel things going on, I don't think.
And there's also the issue of amendment. So under the common law, no matter whether you have an integration clause or not, you can always amend a contract orally or through contact. You know, you can have the rental agreement that says integration clause, rent due by the 10th, and if the landlord is always accepting payment on the 15th, then they have amended their contract. You can't declare a breach by saying.
At least you have a waiver argument.
Right, exactly.
That's not an amendment.
And so, but here in ROLCA, they specifically say you can indeed put it into your operating agreement and enforce it, a term saying it can't be amended except for in writing. Normally, you can always amend by any means, even if you have a clause saying.
So
Is there a distinction between this concept of freedom of contract and the point that was raised about what third parties can rely on? Because I'm sympathetic to the idea that third parties might not be aware of the oral amendments to the contract or the implied amendments. And is it inconsistent to say that people can have freedom of contract, but yet nonetheless it needs to be in writing, but people need to be able, the third parties need to be able to rely on what's in writing?
Right, Roberta, but that's an issue we have with the current statute as well.
Right, no, I understand that, yes, absolutely.
I mean, I would
when they need to know.
just want to get a word in here. Cody pointed out 111. I want to specifically refer to that, which says simply, unless displaced by particular provisions of this act, the principles of law and equity supplement this act. And then the commentary right under that, for this act, the common law rules of contract and agency are among the most important supplemental principles of law. So I think we have right in the contract that we're not intending to displace what would otherwise be our current law.
So let me articulate my concern in response to that, which is, does this in combination thereof language displace the common law, or is it supplemented by the common law? The relevant common law being the parole evidence rule.
I have the same concern you have.
I think it's supplemented by and/or this just is restating what the general common law rule. I just don't think anyone's going to say it displaces it. And I think that coming up with verbiage that goes in here to answer that issue is going to be really difficult to do.
So my proposal, which would be closer to the existing ORS, is to simply strike the language that says, or in any combination thereof, right?
My concern with that, though, is that you have the situation where you may have bits and pieces in different places. So I do not agree with that edit.
Striking the language doesn't preclude a judge from putting bits and pieces together in the absence of a written agreement.
But if you look at
maybe that's what we need to do, though, is a parenthetical that says, or, parentheses, in the absence of a written agreement with an integration clause, parentheses, in any combination thereof. Because that's really the concern that we have. I mean, that we target exactly the concern that we have, is to call out a written agreement with an integration clause as an exception to, or any combination thereof.
Mosen, what would you like the answer to the question to be?
When you have a written agreement with an integration clause, there's nothing in a statute that a plaintiff's attorney could point to that says that the written agreement with an integration clause is not the governing document.
So if your operating agreement has an integration clause, that's it. Whatever you litigate over has to be within the four corners of that agreement.
Unless the agreement itself is ambiguous.
But I think that conflicts with current law, because I think you have the waiver issue that Cody was highlighting, where you have accepted rental payments later.
Those are I'm talking about anything that happens before or contemporaneous with the adoption of the written agreement. That's what the parole evidence rule would apply to. We talk about things that happen subsequent to the adoption of the written agreement, like a modification or a waiver. That's separate issues that I don't think is.
So is that adding a sentence at the end of the section that says, notwithstanding the foregoing, a written agreement with an integration clause shall be enforced?
Well, you don't want to call it an integration clause because there's all kinds of things.
Right, I mean, you have to find out how you describe it. I'm just using shorthand.
I think we get too deep into
But I
weeds
think
there.
then we get to 111, which says that the general common law principles apply. I don't think that the language as drafted supersedes the common law.
All right, so if you're a third party and you want to rely on authority in an operating agreement, it's in your interest that there not be all these other possible things out there, that the operating agreement just means what it says, right?
Right, what you're gonna have to do is affirmatively ask your counterparty for a rep and warranty that the written operating agreement that they've given you is all there is.
Yeah, which
and you're gonna have to have every member sign off on it, because otherwise it's not gonna mean anything.
Yeah, Cliff, I don't think that's gonna be amenable to the ease of transactions, do you?
Yeah, that
you wouldn't
could
want
really
that.
get in the way of everything.
So maybe there's some merit in Mosen's suggestion.
But I understand. I understand what you're talking about correctly. I think it goes to a broader or even different point, which is, should we allow oral or implied and in fact operating agreements? Or are we going to require all operating agreements to be in writing, or at least say only written?
I think we have to allow oral.
From a title company, they would freak out if you said we could have oral operating agreements. I mean,
But we currently
it just seems to me.
There are a lot of states that allow operating agreements, right? So you oral.
Yeah, I don't think we're debating removing oral. I would disagree with that as well. I mean, I think it's just this combination in the integration clause type of issue. It's putting the two together, and it's drawing a line somewhere, so I don't think we take out
I don't think the combination language changes Oregon's law as it relates to interpretation of integration clauses. I don't see there's any change in the law of interpretation of contracts this language would change.
I think that's the intent. I just wish the language was more explicit about that.
That's fine.
Maybe where I come down is, Washington seemed to have adopted the uniform statute. Our statute right now doesn't contemplate that you could have implied agreements, or doesn't include this in combination thereof. But maybe this is a low risk enough issue that doesn't need to be talked about. I don't know. I defer to the transactional.
It sounds like Washington did include the language and Delaware didn't, so reasonable minds have disagreements.
But Delaware never followed the
I guess
Uniform
that's true.
LLC Act to begin with, so.
I guess that's true.
Do we want to take a vote on this?
We don't have to vote right now. Why don't, I tell you what, why don't you give the thought to it, and maybe, let's take it up at the next meeting, and, we'll just put it first on the agenda and get it resolved. And, uh-oh.
Rescue your letter.
I guess I'm not going to be out.
No.
Today.
I'm sorry, Valerie.
No. I'm gonna find it up. I think it's a valid point.
I don't like it. Yeah, I just think that there's.
I'm with you.
All right.
Well, I think we might have a three. I mean, I don't know.
Do you want to take a vote at the next meeting? Or you want to?
I want to move on to the next presenter at the next meeting, which is why I want to finish 107 today.
All right.
So keep
All
going.
right. I don't know if we're gonna. I stepped on some toes here.
John, Lane.
Yeah, Lane.
Would it help the group at all to have somebody from the drafting committee from the ULC on this to offer some perspective on how this has been addressed nationally? Just offer that. We can sure make either staff or the chair or reporter of the drafting committee available if that would be helpful.
I mean, I think it might make sense to flag the issue and say this is not the only place where we have disagreed.
Sure.
And then maybe discuss more than one issue with a member of the drafting committee as we move forward with it.
Sure. Okay, just let me know. Yeah.
I
can make that happen.
All right, so.
Thanks, Lane.
So my understanding then is that we're gonna move on absent most of the suggestions, but reserve the right to revisit it and to present it to the uniform drafters, but we're gonna do that in one fell swoop, so we don't
I think
waste our time.
I think there's gonna be a number of issues.
All right, that's good. Good.
And it might be, maybe a lawsuit and look up and whether court has discussed the situation.
I think that would be
Part of the Uniform
controversial.
Act is
I didn't think the
incorporate
would be that
rulings
controversial.
on the prior, that have been issued before we adopt this. If a court has decided it already, then our courts will follow suit.
Yeah.
So Valerie, are we done with this section?
Yeah, I feel that we are done with this section. How do you feel, Melissa?
It's just a definition.
We haven't actually gotten to
This
is all the definition.
Okay, well, let's talk about 106 so we can hopefully get through 107 today.
Well, hold on, we haven't. Oh, sorry. I think.
Yeah.
Are you okay with the moving on to the
sorry.
definition? Okay,
Okay.
let's talk about 106.
106, dealing with operating agreement. Interesting comparison with ORS, and I'll go through that. So an LLC is bound by and, underlined and, may enforce the operating agreement whether or not the company has itself manifested assent to the operating agreement. So,
statute number?
sorry, what?
What was the statute number?
106. 106. And we, page 37 of the markup here, of ROCA. Our ORS counterpart is compared to 106 and 107 quite small. It says the operating agreement, if any, may provide for the regulation.
What number are we looking at? I'm sorry. What number are we looking at in the ORS?
ORS 63.057.
Okay, thank you.
The operating agreement may provide for the regulation and management of the affairs of the LLC in any manner not inconsistent with law or the articles of organization and may be in writing or oral. Okay? So it's interesting when you look at the commentary under 106 saying specifically to subsection A, this subsection resolves twin questions that have troubled some courts, namely whether an unincorporated entity that has not signed its foundational agreement nonetheless is bound by that agreement, and two, may enforce the agreement that the partnership, and I don't know if that's a typo actually in the commentary, and at the bottom of it discusses a number of cases where those issues have come up, and finishes that commentary. This subsection answers the twin questions categorically and in the affirmative. The section does not consider whether the LLC is an indispensable party to a suit concerning the operating agreement. That question is one of procedural law, and the answer can be determined whether federal diversity jurisdiction exists. So, because you look at our current ORS, and it's not entirely clear if the LLC as an entity viewing its members as separate legal persons, it's unclear whether that entity is bound by and may enforce the operating agreement. So 106A, as the commentary points out, really, I think, improves on our statute there by making that crystal clear. I think probably most courts would get there by implication, but obviously there's been some cases in other states that have gone different directions.
I'm okay with A. Any discussion? Okay.
106B, a person that becomes a member is deemed to assent to the operating agreement. Okay, there's no counterpart for this in ORS at all. And so, I mean, certainly best practices are that you have the new member signed a joinder agreement, that they explicitly become a party to that agreement. Again, though, what happens with this kind of statute is it's meant to fill in the gaps for the hot mess contractors, for example, that bring in maybe a third member. And so that, or maybe there is a written operating agreement, but they don't do a nice, pretty joinder agreement. They're deemed to assent to that operating agreement, and they move forward.
Is there a counterpart to this in ORS? I'm fine with this. I understand why it makes sense. This provision's always struck me as odd because it allows for the absurd scenario where, for example, you want to subject someone to a non-competition agreement, so you make them a member of the LLC that has a non-competition clause for the members of the LLC. The who's now a member never had to assent to become a member. They become a member under this language because they've been deemed to, they become a member and they're deemed to assent to the operating agreement. So now they can become subject to this non-competition clause. Clearly, that's not what the statutory drafters meant, but without having some assent on the part of the member to the terms of the operating agreement, they've deemed to assent.
One assumes that they would have.
But they've assented to becoming a member.
Yeah, and as part of the due
diligence. There's no
diligence.
language, as far as I know, that requires assent to become a member. Correct. Member, I think, is defined. Look up the definition.
Actually, yeah, section 401B, after formation of a limited liability company, a person becomes a member, among other choices, with the affirmative vote and consent of all the members. So literally, all the other members could just say, I want our chief marketing officer to be a member, and therefore he is bound by that agreement.
I want our chief competitor to become a member of this shell LLC we created.
Yeah, right, well,
yeah.
If a member dies, somebody else inherits the membership interest.
Sorry?
Or a member dies and someone else inherits the membership interest.
That's another scenario,
That,
right?
to me, seems more likely than forcing your competitor to be a member. But
I just flagged that this is kind of a weird situation where someone can become bound to contractual terms that they never assented to or were presented. And that's weird, but I understand why this exists.
And the membership interest is a 1/100% of the capital of the company.
But they could be, like, generally a lot of operating agreements will provide that people, if they are assigned an interest, but are not party to the agreement, they don't don't have any of the rights to the
Right.
agreement.
They just become an
or the
economic
obligations. Exactly.
Yeah.
Which this seems to come out to a different outcome.
Yeah, I mean, I don't have a problem with this language particularly, but I think we should discuss it, or at least think about it when we think about 401, right?
Yeah, 401 is a very important
Right.
section, and it's,
We may make changes to
becomes
401
a
that
member,
have an impact on this.
assumes that you've jumped through the hoops of 401. That language assumes that, and so you definitely.
Well, it's the you have, that other people totally outside of your control have, potentially.
Well, I just can't imagine that you're allowed to conscript people to become members
Without their
of
consent.
your LLC.
I'm gonna
Except for the fact that it doesn't say that.
Yeah, make you all.
I appreciate it, but I don't think that's 106's problem.
An LLC membership interest is personal property,
But
so
it's
you
always
can't
there.
force someone to take
Right, but
personal
I think
property.
106 just begs
There
the
is law
question
on
what
that.
401 provides.
This
and
even
then-
gets more amorphous if you start thinking about the implied or oral operating agreements that this person's coming on board
Yeah,
as a
the
member.
commentary talks about that. You need to take care before you agree to
To become a
get
member.
conscripted.
Right. So first you draft them and you enforce the state.
Yeah.
But I think Teresa's
Yeah.
right, you can't force someone to take possession.
You
of
can't
an
force
ownership.
someone to take property.
Yeah.
I
I
mean,
don't-
that's been litigated.
But
You can't do it.
A person can become a member without even acquiring an interest.
Yeah, but that's, again, that's all
So let's circle-
401. I mean, I
let's deal
think we,
with
we
it.
talk
I
about
wanna get to 107.
that in 401.
Don't take the one, two, 'cause we'll talk about that too. Try.
Do we have a problem with the concept of if you do become a member, however, that you're subject to the terms of the operating agreement?
No, I think the concept makes sense. It
That's
does
fine.
allow for some absurd scenarios, but let's deal with it when we get to 401.
So B is currently adopted, check back 401?
Yes.
Cool.
Should we determine the next meeting?
Can we talk about C? Talk about-
Yeah, please, so we have a clean break. I don't think, I could be probably wrong, I don't think C is controversial. Two or more persons intending to become the initial member of the LLC may make an agreement providing that upon the formation of the LLC, the agreement will become the operating agreement. Okay, so stopping there, you can have essentially a pre-formation agreement that essentially says upon the LLC's formation, this is the operating agreement. I mean, that's a bit of a nuance. I don't think it's a particular problem. There's no counterpart in ORS, so I think it's a helpful addition to law. The other piece of this is for single-member LLCs, and the second sentence says one person intended to become the initial member of a LLC may assent to terms providing that upon the formation of the company, the terms will become the operating agreement. So in effect, your single-member LLC pre-formation agreement can evolve into the operating agreement for that single-member LLC. So again, I think C is a helpful addition to law that I think addresses some issues that aren't squarely covered by the fairly small bit of statute in 63057.
I have no problem with C. Anybody?
Sean?
Okay. All right, let's talk about our next meeting.
So I did put out a doodle just to see some potential dates. So far, the one that most people responded to, except for most of them, sorry, is February 20th, which is a Thursday. Of those who've responded, the second most responses were for February 12th, which is a Wednesday.
So I think I'm going to be up at the next meeting, so I should attend.
Oh, yeah.
If February 20th is the best one, I can make it
So
work.
I would just like to point out the CEJ lunch is the 20th. And I think a number of us will probably be going to that. So in between the two, I have a slight preference for the 12th, but does it not work for anybody?
I can't do the 20th.
I can't do the 12th. I can't do Monday or Wednesdays on this term.
Yeah.
Yeah.
Those were,
But that's fine.
again, we had 9 people respond. Those were the two highest votes by a pretty significant margin. I guess.
My preference
So-
would be to the 12th, to the CEJ meeting.
Okay. John, does that work for you?
I don't know, but it doesn't really, you are more important than I am.
Yeah.
And motion, you on, solo next time?
I
Or
am.
do you, okay, so you're not partnering with anyone?
Well, me and Cliff have split up our sections, so.
Article 3, okay.
Yeah, so the sections that come up first are the ones that I've taken.
So,
And I think, Mosen, you're doing some of 4 as well. I mean, 3 does not look very long. And I think Catherine and I are doing some of 4, and I cannot make the 12th, so.
But we're not gonna get.
Presumably, we won't get to 4. Okay, cool. Yeah, cool.
How's Clover look for you?
Killing me.
So 12 sounds like most consensus we're gonna get. Who wants to host?
We can host.
John, should we? We haven't hosted
We can
the
always
first
host.
one.
Sure.
Okay, so,
Cliff is the host.
so I'll check in with you on specific location, but that's David's right, Jermaine.
Okay,
Right.
and then can we set February, please? Or
Oh, that
March,
is
rather?
February.
No,
We
we
can
said March.
Let's look for March, yeah.
Yeah.
Saying bad things.
How
I'm
does-
signing off. Thanks for letting me listen in. Sandy and John, I'll be in touch with you. Thanks for a great meeting. Yep.
How does March 12th look for people?
Thursday?
Thursday?
And doing at least one Thursday will help, because our counterparts from DOJ could potentially come.
Yeah, I mean, I mix it up a little bit.
And this is Mindy. I'm not available on the 12th. We have a lot of events going on at the law school on that date.
I haven't got it.
I'm out of town.
Of March?
Yeah.
Of March, excuse me, yeah.
I run into spring break or something, or?
No, spring break is the last week.
Okay. 19th?
23rd.
I can't do the 19th.
18th?
I can't do
You people are killing me. 11th.
Yeah.
Yeah, good deal. I can do 11, but don't let me be.
11. Anyone want to host March 11th?
We can host March.
Is Roberta still on the phone? I think
Roberta?
I think she said she couldn't do Mondays and Wednesdays for some reason.
Yeah,
I
that's
think it's
correct.
just-
She can do Mondays and Wednesdays.
And if we need to do the 12th, then I can listen in for part of it and just leave the meeting early, which would be fine with me. If Thursday morning's best.
11th.
11th?
It
11th?
sounded like the 12th had too many people who were going to be out of town. I mean,
Yeah.
unfortunately, we're not going to be able to get it everyone, at every meeing.
Okay,
But,
right.
but wait, Roberta, this is your section for March potentially, or no?
Maybe.
I believe it was going to be Roberta's section for,
Yeah.
she was not available Monday and Wednesday mornings.
I guess teaching.
Okay, so does somebody else want to suggest it?
Well, I think if you start a section, we need
Should
to
accommodate
start
her,
online
yeah.
plans, maybe we'll need another Google poll after.
All right, let's do that.
All right, for March, I'll send that out.
I'm already getting your calendar invites. You're really efficient.
Oh, you good?
Already
Oh.
my calendar.
All right. Great, thank you all. So next time, we will
working on it.
finish up 107, I'm being optimistic,
Oh, I didn't mean
and
to send
then
that
we'll
out.
move
Sorry.
on to Article 3.
Right.
I clicked something in my calendar that apparently sent something to all of you. That was
Yeah.
not my intent
Yeah.
at all.
So Cliff?
Paper copy.
Definitely not my intent.
Uniform law.
I'm gonna decline it.
And
got it.
one
You're
of-
gonna decline it?
Or at 63.
Yeah.
All right,
So-
anything else for the good of the order?
You know?
So basically,
No.
Yeah, all right. Meeting is adjourned, thank you all.
And I'll bring up. Yes.
I was just trying to type
Oh,
something.
meeting's adjourned. Thank you, everyone.
My phone.
Automatic population.
It automatically sends it